Good morning. It's 9 o'clock, and I call to order the January 23, 24 rental program special magistrate proceeding. My name is Robert Riggio. I am the special magistrate who will be hearing the matters this morning. It's a fairly simple procedure. When your case comes up and they are listed on the agenda, if you don't have one already, they will be taken essentially in the order that they are shown on this sheet, but there will be one, at this time, minor change I'll get to when we get to the announcements. But at that time, when your case is called, if you can come up to the microphone over here on, this would be your right side, my left, and at that time, please state your name, and you will be sworn in by the board secretary, and at that time, the city will, code officer will be at the other microphone and will provide the particulars of the matter for which you have been cited, and then you will be provided with an opportunity to respond and state whatever you feel is appropriate at that time in response to the statements that are made by the code officer and any other defenses or issues or things that you want to raise at that time. So, the next item on the agenda are announcements.
No, sir. No announcements.
Okay. At this time, I would like to, there was a request that was made by an individual who has to be out of here to move that case up, and that would be case number 8. RTL 01-2406, Deborah Kirkland, and I'm moving that to follow the lien reviews, so it would be just in front of case number 1 that's on the agenda.
So it's going to be right in front of case 1.
We have 5 lien reviews to go through first.
Okay.
All right. I have approved the October 24, 2023 meeting minutes and provided them to the secretary of this proceeding. And at this time, I think it would be appropriate for all city staff who intend to testify in this matter to come forward and be sworn.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
Right. Is there any further business that
No,
needs
sir.
to be taken care of?
Not from me. No.
All right. Then let's begin with the lien reviews. We have a full docket today, so we probably need to move fairly quickly through these and expeditiously, still providing you with an opportunity to state any issues or concerns that you may have regarding these matters. Lien Review 1, RTL 07-21-146, 1012 Hampton Road, Craig Conway. This is a lien review with respect to a lien that was imposed in that matter, which is currently the amount due is $4,200 plus $24 recording fee and a $373.60 in interest. Okay, Mr. Yates? First, let's introduce Ms. Gow. Are you here on behalf of the respondent?
I am. For the record, Jessica Gow, Cobb Law Firm, 149 South Ridgewood Avenue, Daytona Beach, Florida. Thank you.
Okay. Mr. Yates?
The city sees no reason to change its current position. I'm sorry, I misunderstood on this one. We actually reached an agreement. We would be okay with lowering it to 3,000.
Is that acceptable, Ms. Gow?
Yes, we're in agreement.
All right. Then therefore, in case RTL 07-21-146, 1012 Hampton Road, Craig Conway being the respondent, I order the lien in that case number to be reduced to the amount of $3,000, subject to being paid within 30 days, or the fine will revert back to the original amount. And as I state in all of these, if the respondent runs into any problems in making the payment, please contact the city before the 30 days are up. Otherwise, it's back to being square one.
Absolutely.
Okay, thank you.
Thank you.
All right. Lien Review 2, RTL 07-22-147, 210 Auditorium Road. Carlos Espada and Luisa Rincon Espada are here, and there is currently a lien in the amount of $15,000 plus $24 in recording fees plus $913.15. Could you please state your name for?
Yes, Attorney Arthur Huggins.
Okay, Mr. Huggins. And with you is,
Carlos Espada.
okay, will Mr. Espada be testifying in any fashion?
I don't anticipate testimony.
Okay. All right. All right, Mr. Huggins, this is Mr. Espada's request to the city. And if you can state what it is that he is requesting.
Yes, Your Honor, we're asking for a lien reduction. In this case, it was initially considered a repeat violation. I have provided with you some points of reference and authority on repeat violations. In regards to his particular case, Mr. Espada was using Airbnb, and the property was listed on there. However, he did take it down, but he does own multiple properties, as shown in the exhibit. I don't know if you received the exhibit, but those properties were listed, and as his wife was going in to list the other properties, that property was inadvertently put on the internet for approximately 3 to 4 hours. It was taken down. It was put in that night, around 3 a.m., and it was taken down around 7 or 8 a.m. the next morning, once she realized that it had gone live.
The city's
Yates.
position is this is a multi-time offender, and that is why we reserve this fine for people who do it multiple times, so the city sees no reason to change its position.
Okay. Mr. Jackson, do you have something to say on behalf of the city?
Yes, if I may. Anthony Jackson, attorney for the city. Mr. Riggio, in addition to that, this is a situation where we look at issues when someone comes forward and there's this blatant error. We didn't see one here. We're not, and it's not proper to go back and try and relitigate or to even assess the findings, the factual determinations that were made in the proceeding. This went on
Mr. Jackson, if I can interject briefly.
Sure.
I'm here, this is here on, as I see it, on a lien review.
That's correct.
As I understand it, jurisdiction resided with me at the proceeding where the fine was assessed, and then it was transferred to the circuit court. And the circuit court rendered a decision. And
That's correct.
I do not have the authority to invalidate a circuit court decision. That horse is already out of the barn.
That's kind of where I was going ultimately. Mr. Riggio, it was appealed, it went to the circuit court. The circuit court made a ruling. It did not remand it back for you to make additional rulings. So the outcome is that what has occurred stands. We have no changing position from the city because of the prior history in this case. And as to the questions, if those were issues which we don't believe that we disagree with the perspective that there's some issue with the fine, but if there were issues with the maximum fine, those would have been things to be resolved in this appeal. The maximum fine for irreparable reversible is $15,000 pursuant to the statute as adopted by the city under the city's city ordinances. So that's been adopted. It is our maximum fine. In that circumstance, we tend to ask for a maximum fine, and the maximum fine was granted.
If I may follow up, Your Honor. We did have the opportunity to appeal to the 5th DCA, and due to conversations with city attorney, we decided to go this route in hopes that we would receive some type of reduction here. And that was city attorney, Mr. Russell.
Okay. Well, just so it's clear, I'm not here to reconsider the facts of the case.
I understand that, Your Honor.
And as I read it, Mr. Espada had made in his request had indicated that this fine was interfering in some fashion
Yes.
with his ability to be able to make that a useful property.
It is.
But I did not see sufficient materials there supporting that. Instead, it drifted off into let's reconsider the matter. So
Understood,
I
Your
think
Honor.
it would be appropriate in this situation that I would deny the request, but without prejudice. So that if Mr. Espada could come forward with more factual details to demonstrate why it is that a lien reduction is appropriate in order to make that property productive, then that's something I can consider. But at this point, essentially what I have before me is a reconsideration of a case that I cannot reconsider.
Understood, Your Honor. He's willing to talk to you about that now, if he can, before you make your ruling.
Well, generally speaking, the way these are handled is that Mr. Espada would discuss those things with staff, city staff, and get a feel for where things are coming from. And hopefully, as like in the previous matter, it came before you, or before this one, the city, everybody can be somewhere close on the same page. Right now, the city is saying no reduction, and I'm sure Mr. Espada would like some reduction. And so this is really something where it needs to be discussed outside of these chambers first, and then brought back. And then once you've narrowed the issues as to what you disagree on, then I can make a determination.
Your Honor, we did attempt to set a meeting, and I was told that they see us here today, so.
That wasn't from me. However, there are avenues to address. Okay, I'm getting a note from my inspector saying they did set up a meeting with Mr. Huggins. He was a no-show. So that's the position of the staff. I would say, though, the avenues for addressing the issue that he's raised, that first issue, which was the issue related to his ability to obtain the rental license with the fine outstanding. There are provisions in our code on addressing that. That's not something that would be within the purview of the special magistrate or this proceeding. This wouldn't be the proceeding to do that, but within the code, there are provisions where whether or not they meet those criteria for appeal or review of that decision, that's something they would have to look into. So if that's a direction they want to go, that's always something that's open as it is to open to everyone else. As we know, the direction they elected was that they went forward, appealed, and now we're at this status as it relates to the case. And so our position remains the same, that this case is over with, and I think he has the next case as well.
And Your Honor, in regards to the comment that I missed the meeting, that is certainly not true. There was an email that went back and forth with me and Mrs. Barnes, and Mrs. Barnes never confirmed that the meeting was to take place. And I have proof thereof.
Well, as I said, Mr. Huggins, this sort of lies, I think, sort of with you. I'm amenable to considering a lien reduction that addresses the issues associated with a normal lien review. And right now, I don't feel that there is sufficient documentation in the request to support that. To simply say that there is a fine on the property, as Mr. Jackson has pointed out, that you cannot obtain a license while there is a fine, well, then come forward and tell me how you're going to be able to resolve that. And I'm interested in a lien review as I see it, trying to create a productive property in the city that is once again serving a purpose for both the homeowner, but also addressing the fact that Mr. Huggins Mr. Espada had been fined, and he took the appeal, and the circuit court upheld it. So the fine itself has been determined to be acceptable. And what goes on outside these proceedings, I have no control over. But I am saying right now at this point that it would be better for your client to try to engage in a dialogue than for me to say that there's insufficient material here for me to make a decision, and therefore I deny it. And what I would like to do is just deny it without prejudice and give you an opportunity to open the dialogue and at least give me some grounds between 0 and whatever it currently is, the almost $16,000. It's your choice.
I don't understand what's our choice. I don't want to.
Can I say something?
You need to be sworn in.
Yeah.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Very initially, when we had our first violation, which we paid, it was $5,000. Once they put the blue sticker on the door, there's an email and there's a number that you can call. I did both. I received no responses from anybody to try and get some guidance and information on how to rent the property properly. It was basically a process of get the sticker, and then you show up at the special magistrate. And then on the second violation, it was the same thing. And obviously, we are where we're at based on that. So I'm not really sure what the lines of communication are with the city. Obviously, I retained an attorney, but personally, I was not able to communicate with the city effectively. There was no response at all from them. So I'm not really sure, moving forward, how I can effectively communicate with the city and try to reach some agreement.
Mr.
I
Jackson.
just would remind, and I know I don't have to remind you, Mr. Magistrate, but just for the sake of reminding the respondent as well, that a lien review is, the process itself is something that we make available to anyone. However, it's not a matter of right in terms of a reduction or a waiver. And in this circumstance, we believe that the was well supported, and it's gone to appeal, and everything else that you've already said says that this matter, as it relates to this lien, under the circumstances as defined, is resolved, and any request for reduction should be denied. There is an administrative remedy. Whether they missed it or not, I don't know, but there were administrative things they could have considered as it relates to their inability to obtain a license while the fine was in place. And I have nothing further.
Well, again, I'm repeating myself, but I'm saying that I don't see, simply because there is a fine and the respondent doesn't want to pay it or satisfy it, is not a justification for reducing the fine, especially after it's already been adjudicated. However, if there are reasons why that fine prevents improvements to the home, I don't know what, but things that relate to a lien review where you are demonstrating that that reduction is necessary in order to improve the property or make changes to the property or what have you, then that is something I can consider. But I can't just consider that a fine itself serves as a as a reason for either reducing the fine or eliminating it entirely. And I can't. I'm not going to go there. So again, I'm offering you an opportunity to sit down with staff and see if there is something that you can work out that is reasonable and can be acceptable, or at least close, and give me some range between all and nothing. Okay, that is where you are right now. You either get everything or you get nothing, and I think you can see where I'm going as far as the this case is going. So is that something that you would be willing to consider?
I mean, I'm willing to consider anything at this point. I mean, I haven't been able to communicate at all.
And I understand that there was some kind of miscommunication as far as the meeting to discuss the lien review. Okay? And so I'm giving you an opportunity to get together again and see what you can work out.
Sure.
All right. So, Mr. Jackson, do you have any?
No, I have nothing further, Mr. Ridgel. Our recommendation would be to deny the request. If you elect to deny it without prejudice, that's your choice, of course. But our recommendation at this point is to deny the lien request.
Well, that's where I'm leaning, is to deny it without prejudice, which would allow you to bring a new petition, so to speak, forward, in which you address why it is that the lien itself is not the lien as in its entirety, but things that are necessary for upgrades to the home, things of that nature to make it permittable as, I believe, a long-term rental. Is that where this is, were you applying for?
Yes.
Okay. Those things, and then you can work that out.
Okay.
All right. I understand you, and that would then make this property productive for you in terms of you would be deriving some income from it, but the city would also be able to deal with the issue of of the lien and how that is resolved. Okay. So then I'm going to, with respect to Lien Review 2, RTL 07-22-147 at 210 Auditorium, the respondent being Carlos Espada and Luisa Rincon Espada. I am going to deny the lien request, but without prejudice. That's all.
I believe they have the next one as well, but I believe the circumstances are very similar in terms of the request.
Mr. Villamontes?
Okay. Lien Review 3, RTL 07-22-140, 516 Phoenix Avenue, property owned by 516 Phoenix LLC. There is currently outstanding a lien in the amount of $10,654.17. Mr. Huggins, you're essentially the petitioner in these proceedings,
Yes.
where you're asking for relief.
Yes, Your Honor. We're asking for a lien reduction. The owner is experiencing a financial hardship, currently undergoing a foreclosure on the property, and does not have the funds to clear this lien. So we're asking for a reduction in this matter. Your Honor, I do have a copy of the complaint for the foreclosure.
Okay. Do I have to see that? Is that for me?
Yeah.
Okay. If you could come forward. Thank you.
And Your Honor, this was a first-time offense, and there has not been any violations on the property since.
Sir, have you been sworn in as a
No,
witness?
no, Your Honor.
It's not. Could you state your name, please?
Rene Viamontes?
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you. Mr. Huggins, do you have a copy of that for the record?
I just brought one copy.
I'll provide it to you.
Yes. And,
All right.
If you want to hear from Mr. Villamontes in regards to his financial hardship.
Okay. I see that this has been pending now for, since August of 2022,
Yes.
so it's been around a little bit. Is this, has this case moved forward in terms of going to, as far as a foreclosure proceeding?
Yes, there are significant filings on the docket, requests for discovery and things of that nature.
Okay. Mr. Yates?
The city's position is this is sort of a similar story. We attempted to set up meetings. They never happened, so we didn't attain any new information. So the city believes that we should stay with the current fine.
Mr. Viamontes, I see you shaking your head.
Yes, Your Honor, this is nothing like the last case, even though we share the same attorney. This is the first time I bought the building thinking that I could VRBO the units. As soon as I find out from code enforcement that I couldn't VRBO the units, I took it offline. I've never done this before. I've never had a violation. I got a city license and I got the state license to operate this building. I'm paying my business tax with this building. As soon as they told me about it, I took it off. The reason we're here today is because when this hearing first happened, I think in front of yourself, Your Honor, I couldn't make it. I tried to change the hearing date, and they told me I couldn't change it. So I hired an attorney to come in and represent me at that hearing, but everything the attorney was saying was hearsay because I wasn't there. So therefore, I was not, the city had won the case and won a $10,000 fine against me on a first offense. I didn't even rent the place to make that kind of money. And now I'm in foreclosure. The roof needs to be done, so they won't give me a new loan to get the roof done. And the current lender won't modify because I have a lien. Thank you for listening.
Okay.
Mr. Riggio, I only say it's similar because it's similar in the sense that it also was part of an appeal, and the ruling was that it was your decision was affirmed. And you know, I'm not sure. I was not part of this proceeding. I was apparently out for these two. Apparently, they were the same day. It looks like when the fines were imposed. I'm not sure what the difficulty is or the inability to. I say I was out. It doesn't look like it here, but apparently I was. But I don't know the inability to get with the city. I mean, I have had a conversation. I believe this is probably the one that I was told about, and there's probably some conversation we can have that may be persuasive for the city. We just have not had it, and so at this point, all we have is a request. And again, you do have some circumstances, and we're not going to deny that he has a situation, but at the same time, we also recognize that this has gone to appeal. It's been ruled upon, and it's been affirmed. And I'll make it clear, I've always been someone willing to hear from people if they have something they need to tell us. I just haven't heard those things.
Okay, well, this is a tad different than the one before. Mr. Viamontes has testified and that he has a roof that needs repair. That is something that makes that building less attractive in the city, and so these are the kinds of things that there's money being put into improving the area. Now, obviously, I see that some element of a fine is appropriate because of the circumstances of this case, but there is room for discussion as I see it. And in the past, we would have these discussions here, and they could go on for hours, it seemed like. And really, I think it is most appropriate for the parties to get together, have the discussion, and then bring me something, whether it's a range or something of that nature, and then there can be discussion as to the appropriateness of a lien review under the circumstances that are listed and have been discussed. And then, but right now, I assume that right now you're looking for the entire lien to be released,
Yes, Your Honor.
and I'm having a bit of a problem with that. But there may be some middle ground that can work for you and for the city. And so, would it be? Again, I would like to see the city and the respondent discuss this and come up with some solution or range in which that I can make a decision between 0 and the entire fine.
Yes, Your Honor. And if I may, the foreclosure proceedings have already set a trial date, and they're going to get a summary judgment hearing to have a foreclosure sale 30 days after that.
When is the trial date set
Well,
for?
it's on the docket. I just found out about it yesterday. It's a trial date that we can't negotiate. It's set by the court. And I don't know exactly how that works, but I have an attorney for that case for the foreclosure matter, and they told me this yesterday.
It's notice for trial?
I believe so. I'd have to go online to
Your
look.
Honor, if there's a trial date, then it's been noticed for trial.
Okay.
Okay.
And I'm sorry to interrupt you, sir.
Go on.
You were the attorney.
Oh, what's the one on that one? Okay.
But I wasn't there.
Okay.
I tried to move it, but I couldn't move it, and I had attorney Elaine Perez, who's my foreclosure attorney, represent, but she didn't know code enforcement hearings, and so therefore I got a $10,000 fine on my very first offense. And I've never had any offenses on that property before or after.
Well,
I've done everything I'm supposed to do legally.
Well, since I was present, I would presume it was correct. but I remain, open to hear the whole situation. After, I would expect that we've been noticing we would be a part of the foreclosure proceeding as well. I didn't even look into that. A simple conversation or a discussion would have had me to at least look and see what our status was in that as well, since we do have an existing lien. So, again, this sounds like something that probably has room for conversation. But I believe in where we are today, as we look at this as simply as a fine that was imposed and now being asked to alter based upon the final ruling of the circuit court, I believe we probably are not in a fair position. There's things he wants us to consider, maybe we can, but we haven't discussed them. I haven't looked at them. I don't know enough information to suggest a change. And I'm left believing that whatever we settled for was, or wherever we went was in the best we could do at that time.
If I may, one more time, Your Honor. The circuit court on the appeal took both these cases together, and they didn't take my case individually. So the circuit court appeal took the case, heard it from Attorney Huggins, and then 2 weeks later rendered a decision based on the whole of the thing. And they didn't take my case separately and that gentleman's case separately. They took it as a whole. So therefore, that's how the ruling came down as a whole. It wasn't like, Mr. Viamontes, your individual case is different from that case. And I'm sorry, but the open for discussion, I just don't have the time for unless we resolve it now so that I could try to get a modification, try to get it a foreclosure.
I don't know what the time factors are.
If it's been noticed for trial, Mr. Huggins, you must know when it's Or is it Mr. Perez still handling it?
Ms. Perez, yes. Ms. Perez is the attorney, foreclosure defense attorney, and she's out of Orlando. We're out of Orlando. I live in Orlando.
Mr. Perez can give me a call just the same, and we can start seeing if there's a rapid solution.
I mean, I don't do a lot of foreclosures, but generally for other types of cases, when it's noticed for trial, there's a 90-day window. And this board meets every month, or this proceeding is every month.
Yeah, and if necessary, of course, we make special meetings as well. So
Okay.
it's not an impossibility.
Yeah, I don't have the facts. I'm not into simply sitting down and saying, well, I understand your situation,
Yes, sir.
but there's documentation, and you're talking discussion of a range of dollars between what is owing and zero.
Yes, Your Honor.
And picking numbers out of air is not something I'm really want to do. So if Mr. Jackson is amenable to making his office available, and then it would seem to me that then maybe you can come back with something.
I would like to say, Mr. Magistrate, just for both the court's information as well as this gentleman's information, my paralegal generally looks on and she searched and she could not find anything that indicates this is set for trial. And so it appears it's not, but even so, we can, everything else I said, we can do. I'm fine with talking, and obviously it's not my decision, it's the city's decision, it's the client's decision, but we've always been amenable to hearing people out. And in fact, you encourage that, and that's why we were able to come up when we can with agreements in resolving these. So we're open. I believe at this moment, and I think you've already said it, that we don't really have enough information to take a different position than the one we're taking.
Okay.
We received yesterday notice that they're setting it for trial. So that's what my attorney called me and told me yesterday. So I don't know if that's on the court record or if the attorney opposing counsel contacted her.
Yeah.
But I understand.
I'm sure she searched. I'm sure it's an online search.
Yes. So I just need a phone number then to contact Mr. Jackson if we can't resolve this today.
Discovery can go on up until trial.
It's been in foreclosure since this lien, and because it's a commercial property, I don't have the same benefits or rights to defend as I would if it was a owner-occupied property. So this is why it's moving at the speed. That's what I'm being told. This is why it's moving at the
Okay.
speed that it's moving.
If Mr. Jackson has indicated that special arrangements can be made if it turns out necessary, am I correct in that?
That's correct. If it turns out that we believe there's something we need to bring before you in a hurry, we'll make those arrangements and do that.
Thank you, Mr. Jackson.
Okay. Then therefore, in lien review 3, RTL 07-22-140, property at 516 Phoenix Avenue, respondent being 516 Phoenix LLC, I am hereby denying the request for a lien reduction, but without prejudice. And I will give you an opportunity. You can speak with Mr. Jackson and refile something that may be closer in line, or at least provide me some information that I need to make a decision in this matter.
Yes, Your Honor. Thank you, sir.
And just so you're not frustrated, if you contact us, my paralegal will probably talk to you and suggest that your attorney give me a call.
Okay.
So you could just do that as well.
Thank you.
And if you feel Mr. Huggins can help you some way, you
Yeah,
can give me a
I'm
call
just
as well.
nervous and scared, but I'll handle that today.
I understand.
Thank you, sir. I appreciate you.
Okay.
Thank you.
We're done? Yeah.
Yeah, we'll be in touch.
Yes, ma'am. Thank you.
Okay, we are moving to lien review number 4, RTL 10-2362, 582 Revillo Boulevard, Nalini and Aran Karam Chandani.
I believe she's appearing via Zoom.
I'm here.
Okay, could you state your name, please?
Nalini Karamchandani,
And raise your right hand.
right?
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Ms. Karam Chandani, this is your petition. If you want to state what it is that you are requesting.
Okay, I'm requesting for the lien and the to be taken off because of the fact my property is in the long-term rental program, and at the time of that alleged violation, which we did not, which we did not do, we were fined, and but we had a long-term tenant. We are in the long-term renter program. We have a license for it. We provided a notice from our tenant, our current tenant, and also the lease that she has been occupying the house from September 1st of 23.
Okay. Do you have anything further you wish to add?
No, and so because we were not in violation of the code, we would like to have the lien taken off.
Okay. You will be given an opportunity to respond to what the city, because I'm going to ask Mr. Yates, who's the city inspector. You will be
Okay.
given an opportunity to respond to what he says. Mr. Yates?
Okay.
Unfortunately, the site was back up on Airbnb. It was for rental, even to the fact that it looked like somebody had intentionally attempted to obscure what property it was, in my opinion. So the city sees no need to move from our position.
Okay. Mr. Yates, I recall when I looked through this that you had a phone call.
Yes. So when I discovered it, since I had already done the rental inspection, I decided to give her a call. She stated that she did not put the rental back up, but by the end of the phone call, it had been removed. So,
Okay. But in that discussion, I'm looking at dates, and I don't recall the date, but I believe it was like September 15th that you spoke with the respondent.
that sounds correct. And it was removed on that same day.
Was there discussion at that time of the long-term lease?
Well, I had already, not at that time, no. She didn't state that, no. She just said that they weren't doing it, and that was it. But no discussion that they had a tenant in currently.
Oh, that they did.
Well, there was no discussion of that. After the fact, she came back and produced those documents.
Okay, I was wondering about that because it seemed, my recollection that the lease is dated September 1st and the phone call was like September 15th, that it would seem that that would have been something that would have been discussed is how is it that you're in a long-term program and the property is being advertised as a short-term rental?
Wouldn't be the first person to attempt to obscure their activities like that.
Has anyone checked up on the leasing of these premises? I mean, is there in fact a long-term rental in there?
They provided a lease to her. I have not physically spoken with the tenants, no.
Okay.
Mr. Riggio, the rental license was valid as of September 25th, 2023.
And also, to be clear, they have reviews from September 2023 on the ad.
Okay, but the property, the lease agreement is dated, as I recall, is September 1st, 2023. And I'm confused about, I'm confused that there can be a long-term tenant and short-term tenants. I seem to recall at one point, several years ago, there was a situation where there was a straw man that had been interposed, who was acting as a long-term tenant and And in that one, the property owner was stating that, it's the long-term tenant who is acting as the rental agent.
I mean, no evidence is produced to support that. It's a possibility, but
I'm just, to some extent, this is again a lien review, and it's really more like a reconsideration of what took place. What was that 9/1?
Can I speak?
Yeah, this was dated. Oh, it's 2023. Okay, yeah, it was last year. And I'm having trouble with
just one more. And the house's water wasn't turned on in the tenant's name till October 1st. So if they were in there in September, they didn't have water.
Or the water was under the previous owners.
So that indicates that the owner was still controlling the property.
Can I speak?
The lease says that it begins on September 1, 2023.
But they don't get water till October 1st, and they have reviews for tenants staying in it's September 2023.
And wasn't this a prior?
Yes, and this is a prior offense. This is the second time, yeah.
Second time around. It's not a brand new thing to.
No, well, no, and that's most likely why the photos were somewhat altered to try to obscure this property because they had already been caught once.
Could you go in? I'm trying to recall.
The front door was modified to appear as if it does not have a light in it, and light's just another name for the window in a door. And it does have a light in it, but that's pretty easy to do.
Okay. Ms. Karamchani?
Yes. Yeah, I have two things to add. For the water bill, it was because I provided my tenant 1 month free of utilities that I would pay in order to have them as my tenant. So that's why her water bill started on October 1st. That was an agreement between my tenant and myself. And secondly, I did, when the long-term rental, I started like in August. So then it renewed in September of September 25th, 2023. But I paid like a very small, and then I had to renew it, and I paid $14, and I did that. So I was in the long-term rental program at the time of this situation, and I did have a long-term tenant from September 1st.
Ms. Karamchani, I'm looking at the lease, in paragraph 25, utilities, states the landlord will not pay for any of the utilities and services and will be the responsibility of the tenant. I've drafted agreements such as this, and usually some things like that find their way immediately into the lease agreement.
Yes, you know what? Because we're not like a professional leasing company, this is just something that was just verbatim between the tenant and myself. It was nothing that we put in writing. It was just like something that I wanted her to sign the lease. I wanted to help her get into the property and become my tenant. So I offered her that as an incentive.
Well, usually incentives come in front of the lease and not after the lease. Once the lease is signed, it is a binding document, and you don't get any further.
I understand that, but like I said, I'm just like an independent person. So it was just something between me and the tenant that we decided to do on our own that I did not stipulate in the lease because I didn't think that I was going to have any issues.
Ms. Reggiana,
Appreciate the points that are being raised, but at the same time, she had an opportunity to be heard. We had a hearing, whether she was here or not, or we presented all our evidence. These things, even as they're being presented now, have nothing that supports them other than her saying these things. And so that alone, it's not very persuasive to the city for agreeing to a reduction, especially with the circumstance being that this was a prior violation, and this is someone who had come back again with a new violation with an appearance of trying to evade or obscure her, the fact that she was back posting on the site. So one of the things about this, with the whole idea of coming back on a lien review on irreparable or reversible, is that we're still left with someone who can't fix what they've done. It's been done already. They've gotten the benefits, whether they say they were big benefits or small. They've affected the community in a way that it was affected. And our position is that it's really no basis for reduction in this circumstance.
Okay. I am slowly being overwhelmed with inconsistencies. Okay. It is stated that the respondent could not be present because of car trouble. I'm looking back at the minutes. I generally do not like to, if someone has a problem, I try to make every effort to either have them some fashion be present, continue a matter. But I see no reference that anybody tried to reach the city and say, have a car problem.
No.
Everybody has a car phone. Or, I mean a car phone, but a cell phone. And I see a lease, but there are things that were being done that are inconsistent with the lease. Mr. Yates has stated, and he stated at that time, that the photo that was used on the second posting appeared to try to obscure the location. And I have a tenant who doesn't start their water until a month later. There's just too many inconsistencies. So after considering all of these, my decision with respect to RTL 102362, property at 582 Revillo Boulevard, respondents being Nalini and Aaron Carmenchani, is to deny the request for a reduction in the lien. Thank you.
Thank you.
Okay, we are moving on to lien review 5, RTL 092360, 321 Seaview Avenue, George B. Lawrence, who is requesting a reduction in the amount of the lien, which is currently at $15,319.13.
I believe he's appearing via Zoom.
He's right.
Oh, you're here.
Mr. Lawrence, if
I
you
knew
could
it
be
was
sworn
one or
in.
the other, but gotcha. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? And state your name for the record.
Okay. Mr. Lawrence, you are requesting a reduction in the lien that currently exists on your property.
Yes, sir.
Can you briefly state what it is that you are seeking?
We're seeking a reduction. I never had knowledge of any court date, any stop and cease of anything. When the address that was being sent was 2640 when my address was 4620, but I was told that you just have to get it to my address here in Florida, which I was not aware of, but
We did have a meeting with him, and we did come to an agreement that we would be willing to reduce it down to 2,000, seeing as though he was legally noticed, he did not receive notice. We believe he provided sufficient evidence.
yes.
Okay. That's fine with me. Is that
That's
okay
what
with you?
yes, that's, I feel like that is fair.
Okay, 2,000?
Mm-hmm.
Okay. Therefore, in case number RTL 09-2360, property being at 321 Seaview Avenue and the respondent being George B. Lawrence, I order the lien in that case to be reduced to the amount of $2,000, subject to being paid within 30 days, or the fine will revert back to the original amount.
Okay.
Please understand that.
Yes.
If you run into any problem in making a payment, please contact the attorney's office, a city attorney's office, because at 30 days, it reverts back to what it was.
I understand. I 100%
You have an
understand.
incentive to try to get
Yes.
it paid off.
Well, I appreciate everything, so thank you, Mr. Yates, and
Have a good day, sir.
June, thank you for all your help.
You're welcome.
Thank you, guys.
Thank you.
That was 3,000, 2,000?
2,000.
2,000. All right, now we will begin with the hearing of cases, and as I said, we are going to move case number, is it 8?
Yes, sir.
Case number 8, we will hear that one first because the respondent has a class to get to. Case number 8, RTL 01-2406, Deborah Kirkland, cite for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 127 Bridgeport Road.
Could you state your name, please,
Deborah Kirkland.
and raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Mr. Yates, can you present the facts of this matter?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed November 2nd, 2023, and they were notified the same day. The property stopped actively advertising as of November 7th, 2023. There was a daily posted rate of $325. The check-in, check-out times show 4 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Ms. Kirkland?
Yes, sir. I have been a VRBO premier host since 2015. When my husband of 30 years passed away suddenly, my income dropped in half. We had a piece of property up in North Florida. I had no choice but to try to figure out a different income stream because I was too young to collect Social Security and et cetera, et cetera. At that time, I put it under my business name. I did my due diligence with the state of Florida, with the city up there. I've been renting for a very long time. I have hundreds and hundreds of reviews. State of Florida basically says that it allows it prohibits from local administration or municipalities from stopping you from short-term rental. Basically, it says while governments can regulate some aspects of vacation rentals, they cannot limit how often or how long rentals can occur. It even goes on and talks about inspections being limited to building code, basically railings, et cetera, et cetera. I did try to look up something for the city when I put this up on, well, let me just kind of give you a little bit more background. I bought the house, so these have long-reaching effects. I purchased the house in 2019, spent 3 years updating it, remodeling it, not knowing whether I would have another life-changing event in my life. I did it specifically with the intent and purpose that I might be able to short-term rent at some point. So I felt like I did my due diligence. Couldn't find anything under statutes and ordinances under the city of Daytona Beach. I spoke with Mr. Yates a couple of days because I think I received the notice on my door just before the weekend occurred and I was out of town. I spoke to you via email, I believe, on the 7th after it was posted on the, or maybe it was the 6th, after it was posted on the 2nd. You actually told me to go ahead and give you a call. And so I gave you a call and asked what I needed to do to become in compliance. I actually was flabbergasted by the fact that I could purchase a home in an area without a homeowners association, 4 houses from the beach, basically, the world's most famous beach. I know I watched over 2 hours of these hearings last night from October. And so I feel a little defeated coming up here to even begin because it never turns out our way. But anyway, with that being said, during our conversation on the phone, you likened my offense to violating a posted traffic signal of some sort, whether it be a stop sign or whatever. But it was compared to that at that time. I argue that it is not. I did ask for direction on where to find the statutes and ordinances for the city because I couldn't find them easily. I did get them on the second email, which just happened on the 15th, I believe, of this month. Surprisingly, I feel like these ordinances are obscurely hidden within a comprehensive land development code under other properties. And I'm going to argue because I watched so many of these cases from October, and I would say more than 50%, 60% of these people purchase these properties, like I said, long-reaching arms on this thing, purchase these properties fully intending that they're in compliance with what they can and cannot do, only to find out that they can't. Now, Mr. Jackson mentioned that these ordinances and whatever are well supported. I argue that they're not because they're not easy to find. So, especially for first-time offenders, I mean, it just seems like these fees are excessive. I mean, I complied immediately. I never rented my house. I called. The only 2 bookings that I got were for February and March, coming up next month and the month after. One of them actually even asked me privately if I would do it, and I said, no, I can't do it. So I complied immediately, took it down, and since then I've been trying to figure out what direction to take from this point because I spent a lot of money purchasing this house, remodeling this house with the intention to do, so... I moved over here, like I said, I teach at Daytona State College. I commuted for 3.5 years, and I wasn't sure whether I wanted to leave my Winter Park home because I'd been there for 25 years. So I purchased this house fully intended because it was a good investment for me as a widow to be able to try to, get back some of that income that I lost, due to, I don't know. So that's where I'm at this point. I just feel like maybe the city should post signs in the neighborhoods. Maybe that would be a clear, if it's going to be likened to a traffic signal, put it out there where people can see it. So, I mean, I heard so many cases last night of people saying that they didn't know. How do you find it if it's not obviously easy to find? So.
Mr. Jackson, do you have anything to add to this matter
We did.
regarding the basis for the short-term rental ordinance enforcement?
Well, the short-term rental ordinance, and I think the information, if I understood, and I'm sorry, I got to look at your name real quick. Ms. Kirkland, right? Her increase came after she had started doing it.
No.
If I understood right, and I may have understood it wrong, but in any sense, her understanding of the law was, a layman's understanding. She didn't understand the law. The law clearly provides that if it was existing, that it would be in an existing local code, and it would remain part of that local code. In fact, she may be very correct that there may be some wonderful places that we should be able to do this. But under the statutory laws that exist right now, if we make any changes to our existing law, then we have no authority to control this in any way. And our city has not been willing to eliminate the availability of being able to zone for short-term rentals as a tourist destination. So there may be places we want to add, but we're unable to make those changes at this time based on the understanding of the law. And having even checked with the AG to determine that's the Attorney General, that's something we can't do. That being said, some people really don't appear, at least when they come to us, to know, and others do. And they may say they don't know, but a lot of what they're doing and how they're doing it shows that they do. We don't know how to tell if someone knows or doesn't know. We do know that it impacts cities. And some areas in our city and some situations are more impactful than others. But we try to be fair in the way that we apply it. It's from a gravity perspective, we believe that it's without, and you've heard my speech, without having the ability to have a monetary effect against someone who's applying or utilizing the short-term rentals for the economic benefit, and obviously some people with an economic need, but without the ability to affect that by imposing fines, we have nothing else to do to stop someone. And so we initiated this with imposing substantial fines. $15,000 fines was our request on every case when we started this several years ago now. And we've gotten whittled down with understanding, compassion, and fairness. But it's still a penalty. And without a penalty, it's like anything else. Then it becomes a catch me if you can. And we've had those situations as well. So it's always the magistrate, it's always your call on what the fine should be. But the effort of consistency, you've established for the most part a minimum fine of $1,000. But again, it's always your call. And in this circumstance, it's someone who responded immediately, and we appreciate that and acknowledge that. And so we've accepted that as a pattern of how we resolve these, that she responded immediately, and our request is that a $1,000 fine be imposed.
And that's consistent with what
we've done now
what
for
you
at
have
least-
for several years now.
If necessary, I can go through the short-term rental outline that my normal reason for irreparable or reversible. It sounds like Ms. Kirkland has indicated she's probably heard it since she's
I did.
listened, but I'll be happy to present it if it's, I'll be presenting it at some point. I could present it now or present it at another
Well,
case.
I did hear it last night, but I didn't go back and review it. So my question to you is, when does the violation actually occur? Does it occur the first time you rent it, or does it occur as soon as you post it, which is...
As soon as you post it. The minute you post it, the advertisement itself is a violation.
Holding out.
Well, I feel like, irreparable and irreversible are very, very strong criminally indicates criminal behavior. And honestly, from what I saw from most of those cases, I understand that there's always the other side of the fence as well. And I know you've heard it all, guys, because, Your Honor, I heard you say on one of those cases last night, you've been doing this for 4 to 5 years or something like that. You have heard it all. So why does it still keep happening, especially with first-time offenders and people saying that they don't know? Why can't this information be more readily available to find?
Ms. Kirkland, the reason it occurs is that there's a monetary incentive. It is, why do people, and this is not a crime, but your analogy to crime is, why do people rob banks? Because it's monetary incentive. Why do they do economic crimes? And that is the problem here, is that I think the city, it's been it's been in the newspaper back when the newspaper was more widely distributed. I think that it's been on the news occasionally because every year someone tries to change the statute that limits the city in terms of making modifications to its short-term rental ordinance.
Is that what the state statute? Because I
There
heard
is a
someone
state-
mention that, which I have, obviously.
There is
know.
a state statute that says that cities can continue to enforce their short-term rentals, but I believe it was passed, was it like 2010 or
11, I think?
12?
I think it was 12.
And it said that if you make any modifications, you lose your ability, and you have to do the state method, which is basically anything goes, pretty much. They collect the money, they issue the permit, and they say, we'll see you in a year when it's time to collect money again. The city of Daytona Beach, and correct me if I'm wrong on this, also has a short-term, there are a couple enclaves of short-term rental property in the city, and the city licensed those,
Yes.
and
You still have to have a business tax receipt for that. And then we have long-term rental. So it's not that the property has no use.
And
Because you can do a long.
And I recently found out that I'm 4 houses in from A1A. The first 2 houses in from A1A are a different city. Therefore, they're allowed to. So I'm not really sure, like I said, how I would have known. I'm talking to my neighbors. My neighbors are all good.
in law school, we went through something, I think it's called the infield fly rule, where if you do I'm not a baseball fanatic, but if you hit a pop-up, it doesn't matter, you're out, okay? And it's in the infield. And there were reasons why they did this, but that's just, it is what it is. This is a violation. There is a penalty, and
I guess I'm not questioning that I was in violation. I found that out. I complied immediately. That I'm not questioning. I'm questioning the process at this point, honestly.
I think
So
that
that's where I'm at. I do believe
if you
I
really
believe
wanted,
it's obscurely hidden.
I think if you really wanted to have an impact on it, you would contact your state legislator and talk to them about that statute that prevents the city from making, I think, some of the changes that you might like to see. And I suspect that some of the changes the city might like to see, but because of a state law, they lose everything if they make those changes.
Because my logical brain, my logical thinking told me when I purchased this home and did the renovations on this home that I would certainly be able to, at any other place in the state of Florida, I would certainly be able to short-term rent it a
Not
few
in-
houses from the beach.
There are many other cities in the state of Florida who also vigorously enforce short-term rental ordinance.
Miami,
One of
actually.
Miami Beach actually were finding up to $90,000. They ultimately lost the lawsuit and had to reduce it down to the maximums, more reasonable maximums. But at one point, we was finding $90,000.
Well, like I said, I'm not arguing that there was a violation. I'm just arguing the process at this point and the fact that it has to fall back on to a homeowner who had no real way of knowing. So,
Understand?
okay, thank you.
Ma'am, do you have anything further?
No, that's it. Thank you.
Therefore, it is the city's request to fine you $1,000, and that is in line with our past fining
So-
procedure going back several years.
Could I have asked for a reduction because there were several reductions given out in October? I mean, I understand that it's your policy, but, like I said, I mean,
Every decision I try to have a factual basis, and you can ask for something, but then you have to provide some basis for the request.
okay, all right.
Therefore, in case number 8, RTL 01-2406, I find the respondent Deborah Kirkland to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D, Florida statutes for the property at 127 Bridgeport Road, and to have subsequently come into compliance on November 7th, 2023, and hereby order that respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
We'll go back to the normal order of these cases, and we will go to case number 1, RTL 01-2412, Bradford J. Bowles, cited for failure to correct violations of City Code, Chapter 26, Section 26294 at 924 Vine Street.
Good morning, Mr. Riggio. Carl Luxembourg, Inspector for the City of Daytona. My credentials are on file. This complaint was field generated, and the violations are failure to correct rental inspection violations. They were first notified on the 24th of October with the compliance date of the 28th. Since then, they remained not in compliance despite multiple inspections since May. Staff is recommending a finding of noncompliance with the next cutoff date for compliance.
Okay. Is Bradford J. Bowles present, or anyone here on behalf of Bradford J. Bowles?
I received an email from his property manager, Mr. Gomez, this morning and sent him the Zoom credentials, but I don't have any. I thought he would be on either appear or be on Zoom.
Okay, well, if he's not here, he's been properly noticed. He's been properly provided with Zoom information. He could be here. He's not here. And the action at this point is simply a finding of noncompliance, which is being requested. There are no monetary penalties yet against his property.
Right.
And that is the next step in the process, and hopefully he will resolve things and things can be resolved. So therefore, in case number 1, RTL 01-2412, I find the respondent Bradford J. Bowles, whose property is at 924 Vine Street, to be in noncompliance, in order the respondent to come into compliance by, what were those dates again?
27.
January, or we're in February, right? 2/21/24, and the meeting date is 2/27/24.
Okay, to come into compliance by 2/21/24.
Actually, this is the January meeting.
Yes.
So I think you said February. Right, so they'll give him 30 days. He'll need to be in compliance
Yes,
by
he has
February.
time to come into compliance. We're not trying to set him so that he's got to be in compliance tomorrow or anything.
Yep, you got it.
Yeah. To come into compliance on February 21st, 24, or be returned to hearing on February 27th, 2024, before the special magistrate for consideration of a fine of up to $1,000 per day.
Thank you.
Okay. Case number 2, RTL 01-2417, Hancock Property Management LLC, cited for failure to correct violations of City Code, Chapter 26, Section 26294 at 175 Yorktown Drive, number UT4.
Good morning, sir.
Oh, We have someone on Zoom?
Could you
Yes,
state your
sir.
name, please, sir?
Could you-
On Zoom, can you state your name?
Yes, I can. Sorry about that. My name is Christopher A. Bartos.
And can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Bartos, what is your relationship to Hancock Property Management LLC?
I am the co-owner with my wife, and I'm also listed as the manager of the LLC.
Okay, thank you.
Okay. Sorry.
Okay.
Good morning. I'm Inspector LaWanda Domingo with City of Daytona Beach Code Compliance. My credentials are on file with the city. This case did open August 10th of 2023. The owner was notified by posting of the property on August 10th of 2023. My findings is that this is an unlicensed rental property, and I am requesting an order of noncompliance with compliance by next cutoff.
Okay. Mr. Bartos, do you have any response?
I do. Yes, sir. First of all, I'd like to say thank you to Ms. Barnes and Ms. Domingo for being able to coordinate the Zoom meeting for me. It makes it a lot easier. So thank you very much to them for that. With regards to the property being a non-licensed rental property, so we reached out to Ms. Domingo to get the rental license for this property, and she did an initial inspection in which she found a few items that needed to be corrected for it. The initial items that were easy to correct, we corrected. However, the main issue seems to be the issue with the windows. We replaced the windows on the property because when we bought it, it had cracked windows and old windows that were not satisfactory. I hired a general contractor to do that work, and that general contractor replaced the windows but never pulled the appropriate permits for replacing the windows there. So I was able to get in touch with that general contractor regarding the permits. He informed me that he has allowed his GC contractor's license to lapse because of the administrative and insurance costs that come along with it. And so now we are in the process of trying to get, somebody new as a general contractor to do the windows. I asked about doing it myself. However, I was informed that because it's a condominium in particular, the homeowner is not allowed to pull the permits themselves. So we're trying to find a general contractor at this point to do that work for us and just submit the permit.
Okay. Mr. Mango, is that the primary issue here are the windows, right?
To that extent, and the fact that this inspection took place back in September of 2022, I did make several attempts to speak with a property manager that was present at the inspection to get follow-up on, progress for the repairs and things of that nature without success. And that's when I started trying to get in contact with the owners and was able to reach Mrs. Bartos by email back in May of 2023, at which time she told me she would follow up with the property managers and get back to me as soon as possible. That's a response email that I received May 4th, 2023 from Ms. Bartos. I did not receive any more communication from the owners from that time, which prompted, down the line, my posting the property for being an unlicensed rental in August, at which time, when I posted the property, I received a contact phone call from Mrs. Bartos again, where I was able to explain the outstanding violations and to explain to her the process for pulling an after-the-fact permit for the windows that were unpermitted and installed at the property. And, again, just tried to explain that process to her with being told again that they were going to try to find a contractor to pull a permit after the fact. It is a rental property, so a licensed contractor will have to pull the permit. The owners can't pull a permit for rental property. And that leads us here today with my communication with Mr. Bartos last week, just explaining essentially what he spoke of today, that they're still in the process of trying to get a licensed contractor to pull an after-the-fact permit for the window installation.
Okay. Mr. Mango, are the property occupied?
Yes.
Did you have an opportunity to see if the windows work?
At the time of the initial inspection, yes, but the problem in and of itself is that they were installed without the permits. They are operable windows with no life safety issues, but I wouldn't be able to say for a window that is unpermitted. You know, a building inspector has to go in and say, and it was installed properly and sign off on that. But I didn't have a problem, you know, opening those windows while I was there.
Okay, Mr. Bartos, it sounds to me to some extent you are in a paper violation issue. And I work with people as long as they work with the inspectors and try to resolve this. And I understand you're probably having some difficulty getting a general contractor to basically take responsibility for somebody else's work.
That is exactly correct, sir.
And I wish you good luck in trying to find somebody. But keep the channels of communication open with the inspector. And as I see it, this will ultimately all be resolved in some fashion. But you need to keep trying to find somebody to do that, and hopefully get all of these, the loose ends wrapped up and get your license, and then things will be fine. So I know it's going to be frustrating now, but you will ultimately find that you can work through the process. And like I said, I understand your situation, and I will try to work with you as best I can from my standpoint, because the next step after noncompliance is levying fines. And I understand your situation. And as long as you're making a good faith effort to try to resolve things, I don't want to go there with fines if I can avoid it.
Thank you, sir. We appreciate your consideration for the situation, and I think your description of a paper violation is probably the best way to put it, because my wife and I have been trying very hard to make sure this is a good property that has everything taken care of for it. So we will continue to seek out a general contractor. We're working with one right now who might be able to do it for us, and hopefully he will come through and actually be able to sign off on the permits.
Okay. I'm not trying to downplay what are considered building code violations, but a lot of contractors do the right work, and you just don't have the permit, and you need to have somebody who can get the permit. Okay.
Yes.
So in this case, are you looking for the 2/21 date for
Well, we can, just as a checkpoint, I am anticipating correspondence from Mr. Bartos just to let me know what the progress is. So if there's progress, we can always consider amending to next cutoff at the next hearing. So
Okay.
I want to see what happens in 30 days.
You will be set to for the next hearing, which is on February 27th, and there's a cutoff date on February 21st. Your communication with Ms. Tomengo will determine whether we just continue it because you're showing good faith efforts moving forward, or whether potentially there's a fine. It doesn't appear that you are headed towards a fine, but there have been many people who just suddenly stop trying to move forward, and we want to keep the lines of communication open. And one incentive for that is the possibility at some point of a fine being imposed if you don't keep your inspector informed as to what's going on.
Understood, sir. We will continue to make progress.
Okay, so therefore, in case number 2, RTL 01-2417, I find the respondent Hancock Property Management LLC for property at 175 Yorktown Drive, number UT4, to be in noncompliance, nor the respondent to come into compliance by 2/21/24, or be returned to a hearing before the special magistrate for on February 27th, 2024 for consideration of a fine of up to $1,000 per day.
Thank you.
It doesn't sound like we will go there, and good luck.
Thank you, sir. We appreciate it.
Thank
Okay.
you.
All right. We are now moving on to the irreparable, irreversible cases. Case number 3, RTL 102369, Robert and Nancy Beverly Hackman, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 715 South Beach, number 112D.
Ms. Hackman, can you hear me? We can't hear you.
Can you hear me now?
Yes. Could you state your name, please?
Nancy Beverly Hackman?
And raise your right hand?
Yes,
Do you
Nancy
s-
Beverly Hackman.
Okay, and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Okay. Mr. Yates, can you state the city's position in this matter?
Yes. But before I do, this is a case that we brought back due to the fact that you wanted her to have additional time to remove the property from the website.
Okay.
And she did do that after the hearing within 1 day. And the original ask from us was $15,000. But the case before you was a zoning violation. This case was field generated. The property is zoned MFR 40. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed September 13th, 2023, and they were notified the same day. The property stopped actively advertising as of October 25th, 2023. The daily posted rate was $87. The advertisement displayed 1 review. The check-in, check-out time were shown as 4 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $5,000.
Okay. Mr. Jackson, do you have anything you want to add to this proceeding?
Yes. Ms. Riggio, I'd like to state the city's position as relates to our request that you make a finding that these violations are irreparable and irreversible in nature as provided in Section 16209.091D of the Florida statute. The nature of the violations are as follows, and I'd ask anyone who is listening on Zoom in the waiting area, as well as everyone in here that would be coming before the magistrate for these short-term rental violations to listen in. Of course, I'll present this as many times as you all desire, but if you listen in, you can acknowledge that you may have heard it already. The city's position is this, that there's a beneficial gain to the property owner who is advertising conduct that is prohibited by the code. The effects of renting property or holding out property as vacation rental cannot be reversed or repaired. Property is advertised worldwide, marketing a destination that draws people from all over the world for principal special events such as Daytona 500 races, Bike Week, Biketoberfest, and throughout the summer and spring to the world's most famous beach. The properties may also be marketed as a draw to nearby destinations such as Disney World and Space Coast. Once the properties are advertised, they are never truly unadvertised. The reality of the World Wide Web is that you cannot push such advertisements back into the tube. Information posted today can be printed and saved, forwarded, retweeted, and even copied and pasted on other sites. And it limits the city to the only solution for the advertisement is to require that all postings be removed. SmartSightings.com marketing website provides that as of October of 2023, 4.95 billion people around the world use social media and can be reached by the advertisement. There are effects to this advertisement. The information has long-range effects in luring patrons under contract to participate in unlawful stays in our city.
The patrons risk poor health, poor safety and welfare due to unregulated or self-regulated vacation accommodations that patrons enter into at their own risk. One single day of advertising can potentially book a property for the whole year. These promised stays are potentially to the detriment of the patron, and they're definitely to the detriment of the licensed hotels, motels, and lawful vacation rental that have gone through proper zoning regulations, proper inspections, proper licensing, proper insurance, and proper taxation that's required by law. The transit nature of the rental limit the means of the enforcement typically to identifying advertisements. By the time code enforcement arrives to properties, the transient patrons typically are gone from the property, or they're claiming some misleading relationships that are often contradicted by the advertised visitor comments or reviews. The monetary effect of these unlawful rentals is tax avoidance, inadequate insurance coverage, but mainly unfair business competition against lawful accommodation businesses and lawful vacation rentals. The community effect is that transient businesses are within unauthorized residential neighborhoods, and they affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods, and they diverge from the traditional and reliable residential norms. Our city commission received a demand from the business community, which has led to a request for a strong deterrent to those that are raking in profits, avoiding state and local taxes, avoiding zoning requirements and regulatory controls. We have all seen rentals going for amounts as much as several $1,000s a week and realize substantial fines is the only deterrent tool available. By the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests that the magistrate make a finding that these violations are irreparable or irreversible in nature. And also, we asked the magistrate always to look at the gravity of the violation. As I've said before, earlier in these proceedings, that there was a time when some cities, namely Miami Beach, there's a case out there where they were allowing the fines to multiply based on repeat violations to $90,000 or more, and impactful fines. The court felt that they were excessive, but the statutes do provide for a $15,000 fine per occurrence for irreparable, irreversible violations. We, at one time, were asking for that on everyone because all cities, the businesses, all look at this as something that has an impact on the communities as I've described. However, we have adjusted to the manner in which the magistrate has ruled over the years, and we acknowledge that sometimes there may be circumstances where a lesser fine may be appropriate by the magistrate's review. And so in this circumstance, we're looking at the gravity of the violation and the effort of the respondent to come into compliance. We are asking for a $1,000 fine in this case.
$5,000.
$5,000, I'm sorry. I'm asking for a $5,000 fine in this case. And so with all that being said, we ask for you to make those findings at the conclusion of this case.
Okay.
Hello?
Yes, Ms. Hackman, this is your opportunity to make a response.
Well, me and my husband did purchase this for our retirement home, and we were under the impression by the realtor and the homeowners association that it was a 30-day rental. And when Mr. Yates cited us, that's when we found out that it was not a 30-day rental. It was a 6-month rental. and we were misled by our homeowners association and the realtor. And after our meeting with Mr. Yates, we went through the process of taking it off the advertisement. And I asked for leniency. I live in Detroit, and I've been on strike for almost 2 months. So it put us in a financial position because I don't get paid for walking the strike line.
Ms. Hackman, this matter was previously heard last year on October 24th, and it was
Correct.
continued to today. As Mr. Yates has stated, you were notified on September 13th regarding this matter.
Yes.
And it took until October 25th before the notice or the advertisement was taken down. I'm trying to understand why.
Because I had documents that said it was a 30-day rental. And when I went to court, I brought those in, and it's obvious now that whatever the city ordinance is tops whatever the homeowners association says.
Well, Ms. Hackman, I assumed that beginning as of September 13th, you could have spoken with Mr. Yates and said, my homeowners association says it takes 30 days, at which point he would have, I expect, said the city of Daytona Beach, which is, it's sort of like an army, the generals control, and just because you get an order from a sergeant doesn't mean that you necessarily have any, can rely on that. And the city has a superior position to your homeowners association. And
I'm aware of all of that now.
well, when I have, the city has provided for a lesser fine for people who respond immediately and don't make claims that are just don't have any bearing. When a city tells you something to do something, that ought to on its face be superior to any homeowners association document. And that's just sort of a matter of general knowledge. And I understand your situation. And, I understand that many people are apparently stating that they have been misled by realtors, et cetera, but this is still a business type operation, and you are the business, and before you enter into it, you should have an obligation to see if it's legitimate or not. As opposed to just accepting a check from a VRBO or an Airbnb client who happens to stop in. And I'm not inclined to make any change from the request asked for by the city. So therefore, in case number 3, RTL 102369, I find the respondent, Robert and Nancy Beverly Hackman, who have been in noncompliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible. Because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 715 South Beach, number 112-D, and to have subsequently come into compliance on October 25th, 2023, and hereby order that respondent shall pay a fine in the amount of $5,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
Thank you.
Case number 4, RTL 01-2401, Carlos Ramirez, a cite for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 116 Bellevue Avenue. Mr. Ramirez,
Could you state your name, please?
sworn in, please.
Carlos Ramirez.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right. Mr. Yates, can you give the particulars of this matter?
The case before you is a zoning violation. This case was field generated. The property is zoned MFR 40. Short-term, other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed October 6, 2023, and they were notified the same day. The property is still actively advertising as of today. The daily rate posted on the advertisement is $300. The advertisement shows a rule of no more than 5 guests. Due to the nature of these actions being irreparable and irreversible, and the actions of the property owner, the city is asking for a one-time fine of $15,000.
We spoke once before and it was taken down the same day.
Yes, but unfortunately, you have a VRBO ad, which is up right now and bookable for your house. Unfortunately. You got to take them all down, not just...
Oh, I wasn't aware of that. And then I tried to contact you for a Zoom meeting. Nobody got back to me, so I had to hop on a plane. I left you 2 voicemails. Like, I'm completely new to all this. We spoke. You said $1,000 fine. I said, no problem. I said, how do I pay it and how do I get in contact? You said, reach out to me. We'll set up a Zoom. I said, okay. And we'll do it. We'll take care of everything.
Mr. Ramirez, please address the matter.
I'm sorry. I've never done this before.
Okay.
Unfortunately, yeah, the ad's still up right now and bookable on VRBO.
So what ad was taken down?
Airbnb.
Okay.
The Airbnb one I did myself, Your Honor.
Yes.
The other one I wasn't aware of. I live in New Jersey. So I reached out to a marketing manager and the one I was made aware of, I took down immediately.
Okay. And you have a marketing manager?
Yes, well, young kid that I hired.
Okay. And you said you reached out to him and...
I thought this was the only one. I didn't realize there were other ones. I've never seen this before.
You're saying that somebody posted an ad without your knowledge?
Yes.
But were they working under you, under your direction? You hired them?
Yes, but I've also, as soon as you reached out to me, I reached out and said, cease, desist, stop all of it.
He did on the first ad, but...
Well, I'm trying to understand how you could have someone working for you who was not, I mean, the violation is essentially short-term rentals. VRBO is short-term rentals.
Yes, so the kid was designing websites for me and everything. He no longer works for me. So now I have to find a platform and disable whatever it is.
This is a matter of coordination, as I see it, between you and the people who work for you. And I don't necessarily see that as a legitimate excuse that someone who you hired, who should know to take things down, didn't do it, or that they did things without your knowledge and you weren't minding the store.
I understand, Your Honor. The one that I was made aware of, I immediately took it down the same day.
Okay.
That's true.
All right, well, but...
When you say the one he was made aware of, just for clarification, the one that you notified him?
The one that I originally notified him on, I found this late Thursday.
Okay, so...
If I had the knowledge, I would have shared it with him at the time.
Okay, So,
But I did tell him that all short-term rentals needed to be removed and all future bookings needed to stop. There was no confusion there.
I thought that's what I did.
Okay. Were there any postings on the VRBO site?
You mean reviews?
Reviews?
No reviews. And I did not observe anyone staying at the location when I did my checks. Just someone working on it.
however, isn't it true that everyone doesn't review?
Oh, very, very true. In fact, many hosts block reviews as a way to, once again, obscure it from me.
The house is not finished. Nobody
Not
stayed at
saying
the-
that he is, by
No,
the way.
I understand. Thank you. Nobody's staying at the house. The house isn't finished yet. I'm the only one that's ever stayed there. That's actually where I'm staying right now. They come here to go to court.
Okay.
I'm asking for one chance. It will never happen again.
So we have a house that's not finished that's being posted for availability for rent. What's being represented?
That's the inside of the house?
Yes.
And am I seeing rooms without any furniture in them?
I'd have to look.
those
Keep going.
first-
That's the pool.
Okay.
Yeah, the house isn't even that color anymore. And one of the bedrooms had a bed, one did not.
The living room's furnished, but you're not going to see a lot of interior photos because I didn't have those to compare. I just had the
right
exterior.
there, that one room at the top left corner. What is that?
That's the pool facing the
that's the
back
pool?
towards the construction of that old, I believe it was a mortuary, maybe? Funeral home?
Okay. Okay, I see.
It's actually how I was able to find it because it's just such an iconic build right now in the city.
You know, before we get any further into this matter, Mr. Jackson, did you have anything that you want to put in as the record?
Yes.
Mr. Ramirez, I previously provided to the magistrate the city's position regarding irreparable reversible.
Yes, sir.
That he makes and request that he make a finding that this is irreparable and irreversible in nature. I could present that again to the magistrate if you so desire. If you have anything you want to say regarding that or challenge that, you have a right to do that, even through my discussion now or from what I said earlier.
I'm 100% in the wrong. I just asked for leniency and it'll never happen again.
Okay, so in that, by saying that, you're waiving the necessity for me to read this again into the record.
Yes, sir.
Okay, and I would ask the magistrate if you would just adopt as my prior request on a previous proceeding.
Okay. And let the record reflect that Mr. Jackson's statements regarding irreparable and irreversible as provided in the previous case number 3, RTL 102369, are incorporated into this matter.
Is there a map or something that I could, because I looked, I couldn't find anything. I just want to make sure that I never get myself in trouble like this again.
Yes, if you look in the city's GIS map, there's an interactive overlay that shows where short-term rentals are allowed. And you can just Google Daytona Beach GIS map and it'll pop right up.
Thank you.
Okay. And Mr. Yates, is the city's asking for 15,000?
Yes, because the ad's still up as of today.
I will get whatever ads are removed by today, Your Honor.
Are they still up?
Yeah.
Oh, well,
You're saying that's live and now?
It's live now, and you can book, see, January 24th to January 31st. Book now.
okay. I think the last matter we had, I felt uncomfortable placing a fine on it while the property was still in non-compliance.
Yeah, we've collected 0 money, 0 booking, 0.
And my feeling is that this might be one that we want to continue as well, so that this can be brought to us with all things taken down and then I can measure the speed with which Mr. Ramirez gets this taken care of,
Could,
and we can find something that may be less than what the city is asking for.
can you give me an hour, Your Honor? That way I don't have to fly back.
Oh, are you from out?
New Jersey.
If you think you can do it in an hour, we can continue this till later in this proceeding.
Excellent.
Mr. Yates, would you be able to pull that up and see that
Uh,
that's,
oh, absolutely. Yeah.
okay? And you're from out of town?
Yes.
Okay. My idea is I would like to see you in compliance, and I'm sure you would like not to be here, and that would be fine with me.
Excellent, Your Honor.
Is to get this resolved. Okay.
We're
Well,
showing a New Jersey address, so that's correct? You're here from New Jersey? Or?
Yes.
Okay, just
So-
for clarification.
we will continue. I expect we will probably still be here in an hour.
Okay.
So we will continue it for now, and when you return, we will reset. So this is, just so I have this in the record, case number 4, RTL 01-2401, Carlos Ramirez matter is being continued for consideration later on during this proceeding.
Thank you, Your Honor.
Okay. Good luck. It being 10:57, this proceeding is hereby to be recessed for the next 5 minutes.
This is
We have continued case number 4. Do we have a case that needs to be, anybody who needs to be moved up? Did you say number 9?
Yes, case number 9.
Okay, we'll take that one out of order. And then we'll go back to the previous. Okay. It being 11:10, I call this session of the Special Magistrate Session for January 23, 2024, back in session. We are going to take a case out of order, case number 9. Is there someone here on behalf? Yes. Case number 9, RTL 01-2407, Kimberly M. and Bruce W. Woodburn, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.8.2 at 1225 Sunland Road.
Your microphone, Mr. Riggio. Could you state your name, please?
Bruce Woodburn.
And raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Yates, can you provide the case particulars?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed October 31st, and they were notified the same day. The property was not actively advertising as of November 7, 2023. The daily posted rate was $200, and the advertisement displayed 7 reviews. The check-in, check-out time were shown as 4 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Mr. Woodburn?
Yes.
Oh, before we do that, Mr. Jackson, do you have something to say?
Mr. Woodburn, I don't know if you were in here when I presented to the magistrate the city's position regarding irreparable and irreversible.
Yes, I'm quite aware of it. Yep.
Okay, and if you have heard that, then my question for you is that something you need me to read again into the
No,
record?
sir, I do not need you to read it again.
Okay, and so you waive the necessity for that to be?
Yes, sir, I do.
Okay.
Okay.
And understand you still have a right to address it in any manner which you choose?
Sure.
Okay.
Sure, absolutely. So, Your Honor, there,
Mr. Woodburn, just have to say a couple words.
You do,
Before you
yep.
can begin. Therefore, let the record reflect that Mr. Jackson's comments regarding irreparable and irreversible that he provided in case number 3 are hereby incorporated into this proceeding, into this matter. Okay, Mr. Woodburn?
So I had been before the court for back in, I believe it was July, and at that time, I was fined $750 for posting a property online, which I immediately removed. All my properties were removed. I was unaware of it, and I paid the fine, removed everything. I don't know when those reviews came in and for when they were. So I can't tell you because my site's down and it's been down since your request. And everything is off. Now, keep in mind, I was fined for having it posted on a site even though I had a long-term lease for a 1-year lease. So, and I paid the fine. I agreed. I made a mistake by posting it online and everything was removed. I just don't know when those reviews were for. I have no knowledge of them. I don't have any knowledge of who it might have been or when that stay was.
We can look at the reviews right there. The first stay is stayed 12 days in August 2023. The next stay is stayed 7 in July 2023.
Yeah, so like I said, Your Honor, I removed everything at your request, to completely complied, got my licenses, had my inspections, did everything, and removed everything from the sites.
And that was,
I can't tell you what date it was, but by gosh, after coming here and being in front of this and being fined, I didn't want to. I didn't want to take any chances, so I can't tell you what date it was. I'm not a professional house leaser. This is my own residence. I'm using it as my property right now, I can't. I'm not going to tell you that I didn't make the mistake before, but I reconciled it and made all the corrections necessary. I just don't know. I can't be honest as to when those reviews or when they stayed there. And I don't even recognize some of those names.
The reviews are pretty clear on when they stayed there.
okay.
They list out the month and the number of days.
And I'm confused, Mr. Yates. If I can, I just want to understand all the facts here. Mr. Woodburn has been before me before.
I obviously, in my research, I missed that he'd been before you before, and so
He should have kept his.
Yeah, it's lucky for him. I only asked for 1,000, but yeah, normally, had I had that knowledge before, I would be asking for 15 right now.
Okay.
Well, you pretty much addressed what I was about to address, which is, Mr. Woodburn may want to recognize the benefit of where we stand. We did not indicate or address the issue of prior violations. We didn't realize he had them. We're willing to stand where we are today, as it is today, if that's what he wants, or we can come back and address those as well.
Mr. Yates, it's kind of a technical question.
Mm-hmm.
Mr. Woodburn has said that he took everything down back in, was it July of last?
Well, I can't recall when it was,
In
but
the
as
summer.
soon as that happened, I removed everything.
Is there some way that the site that you picked up on could have been revived?
Yeah, he can just click a button and turn it back on anytime.
Okay, but for the people who place reviews on it,
Oh, no, that means that he put it back up.
No, that's not true. It's not been up. That is not true.
Well, as you can see, we have the photos, so we know for a fact it has been up. We know when I took them, so that's for sure. That's unquestionable. As far as everything else, I can't tell you when he reactivated his site.
well, I'm trying to understand. it's like a technical type issue. If someone takes a site down, and then you later on can pull that site up, and
No, I can only pull it up because he turned it back on. It's not just sitting out there for people to view forever. If you've turned it off and removed the listing, it is no longer searchable.
okay. And when you got the latest one,
Yeah.
there were reviews on there?
Yes.
And were they dates? What were the dates of the?
The first is the review happened October the 8th, 2023, but they stayed in August 2023, and that's listed on there. The one below it, the review happened on August 6th, 2023, and it said they stayed in July 2023. And the one below it, it says it was on June 7th, but it's cut off because I don't put all the reviews in my presentation.
Okay, so the two at the bottom would appear to me to fall within the scope of what you were talking about.
Yes, sir.
That it's just pulling up old history that was already there.
Yes, sir.
Perhaps when this matter was heard
But
previously.
not August 2023.
But August 23, and,
Yeah, and it was bookable. If you look, it wasn't that you could also book new stays at that time
I
period.
can assure you that there was nothing that was bookable post that last hearing.
If you look at the bottom right-hand corner, you'll see I've placed my dates in there. I see November 1st and November 8th. That's letting you know that it is indeed open for bookings.
That is not correct. I promise you that site, I can't even get into it. I completely removed everything.
Correct. Now you can't because it was removed on November 7th, 2023.
That's incorrect. I'm just telling you it's incorrect. After coming here, I removed everything. I complied. Carl came out and did an inspection. I did everything that the court asked me to do. And I just don't know, I can't tell when the people stayed. I don't know if that's accurate or not, but I'm not out of compliance because I am not posting it on any websites, and it has not been posted on any websites at all since that occurrence. I have been in complete compliance, and I intend to be in compliance.
I mean, I can't speak to what he's saying. All I can tell you is that it was up and it was bookable on October 31st, 2023. Why he had it up, I don't know.
know the date that Mr. Woodburn previously appeared before us.
That would have been on July 27th.
There you go. So 100% we can say the August stays would have been beyond that.
And the August one is, the October 8th posting is stating that I had a great time in August of 2023.
Correct. And the way that you get to review it is that you have to send money through Airbnb or you cannot leave a review. So it's only an account who has sent money for those dates, then they automatically attach that at the bottom. That's not something that you write in. That's something that is put there by them to help verify for other people that the review is legitimate.
Wow. Is that the review, Nasty Neighbors?
Yeah, they weren't happy.
Okay. I mean, the computer screen speaks for itself.
And Your Honor, I see that as well as you do. I can just tell you that everything was removed. There was no more bookings. There was no more. I don't know when these people stayed. I don't recall, but I can tell you that everything was shut down. Your code says you cannot advertise on any short-term rental medium, and I complied with that immediately.
Mr. Woodburn, I understand that, and you certainly sound like you mean it.
Well, that's
But
because it's true.
We have, the documentation suggests otherwise.
Well, the documentation is a review, and there's nothing in the code that violates a review. I can't tell you it. I can't tell you, and I can't examine that person and tell you whether that was a legitimate posting or not. I don't know that.
But it's, I can't read that from here. Does it reference a date of August when they stayed there?
The one in,
In the very bottom, it says stayed 12 nights in August 2023. It's below the Seymour.
Mr. Woodburn,
yes, sir.
do you live in this area?
Well, I live in Orlando, and I stay here on the weekends.
Here's what I'm considering in terms of resolving this matter. You probably have the information as to who stayed and when and all of that good stuff. I have one, you certainly sound like you mean what you say, okay? But I'm also looking at written documentation that contradicts that. If you can try to determine what's going on and where that occurred from and then get with Mr. Yates. And what I'd like to do is just continue this to the next proceeding. And then, because I am conflicted with essentially written evidence that contradicts your oral statement.
Well, and as he said, that date's not truly important because the violation itself is the advertisement. And we all agree that it was up on October 31st.
Well, we don't have anything to show that it was up.
No, all my files are date timed, so we do.
I understand that, but that property was not on. I can't attest to the review, and I'm not going
Well, no,
to.
you don't have to test the review. What I'm saying is that it was available online on that day. That's what we know for sure,
How do
and
we
that is
know
the
that
violation.
it was available online for that day?
Because I time, date stamp all my files that are added.
And this is sworn testimony?
Yes, my sworn testimony as well, that it was up on that day.
On that date, you pulled this, and that's where you...
Yes, sir.
Had it printed.
Yeah. So no, it was up and it was available and it was being advertised. So whether or not the review came in a month later, which technically should not be possible according to VRBO, seems immaterial in this matter.
Honestly, Your Honor, I'd like to resolve this today if we can. I'm telling you where I went. I'll tell you what I did wrong, and I tell you what I did right. But I completely complied with everything, every single thing.
I understand, sir. I can't. I hear you. You are very convincing, so to speak, as to what you say. But we also have written and my concern is, I know computers do funny things. And
he's also highlighting, you can see the date on my computer in the bottom right corner as 10/31/2023. So unless it's to say that I purposely manipulated the photo, then they show accurate.
I'm not suggesting that you did that whatsoever. I'm just, I told you what I did. I'd like to resolve this today if we can and move on. The property's in full compliance. It's not rented at all right now. I'm using it for my own purposes. And if you could give me some leniency on the $1,000 fine, reduce that to maybe $300, and we can settle this and be done today, and I can get back.
500.
Well, Mr. Magistrate, before we go, just saying that given the leniency by saying $1,000 based on a past history of this being a prior violation, these questions are questions that, he needs to be able to answer it for himself, because we'll go on and find it again. If there's some mystery way that this is popping up on him, or if
he has someone else that's involved in.
There's no one else involved in this other than my wife, and she doesn't know how to use it. And I'm going to be honest with you, I'm not very good at it myself. I don't navigate websites very well. I've ordered things on Amazon I didn't know I ordered. I'm not going to attest that I'm an expert at it. I'm not a property management company. I know what I did wrong based on my last hearing, and I rectified everything. And I just can't attest to when the reviews were, and I can't attest to that. So, I don't know how to go in and even check it, Your Honor, without activating it.
But there is a review. What bothers me is apparently there is a review that includes a date that is after the date of when it should have been down. And I am not, I understand, and I'm taking into account your demeanor and what you say, but I still can't overlook that, and that is what it is. But I'm thinking again of $500 fine. And that resolves this.
Thank you
I
for-
don't, if you came back again with something like this, I understand that, but the dates and everything.
I understand, and it's confusing to me as well, and I don't have an answer for it. I honestly don't.
And I understand that working with Airbnb, those people and VRBO, they don't like to disclose anything, and but when it's up, and it's up, and you're sort of getting the benefit of the doubt right now as to your demeanor is saying that, you know, you seem to be forthright that you intend to take it down, but yet it's there.
I promise you it was not there. I guarantee.
Well, it was there, and that's the problem.
You mean posted for rental? It was not posted for rental. I promise you it was not posted for rental at that point.
Well, as Mr. Yates has testified, in order to have left a comment, it had to be posted, and quite frankly, again, it's with respect to a rental that occurred at a time after it should have been taken down.
And what could have happened is there could have been a tenant that had booked it and it was already down. And I don't know if my wife had them stay there or not. I can't attest to it because I don't recognize the name, but I can't attest to that. All I know is it was down. I complied with everything.
So someone else had access or could have had access.
They could have, but I can't attest to that. I don't think she did.
I mean, that's a much simpler explanation than the machine running wild and just automatically on its own coming up.
Yeah, they don't do that.
Okay.
Well, I don't know what they do or don't do. All I can do is tell you what I did and what I didn't do. And I'm not telling you I wasn't in a violation initially, but I corrected that immediately upon your request with no delay. So, that's all I've got. I mean, I'll accept the fine, Your Honor.
Okay. Under these very unique circumstances, I'm going to impose a $500 fine. And we resolve this, but Mr. Yates, if you could give some thought to, you know, I don't want to see other people coming in with this, because I think it's possible, as Mr. Woodburn stated, that other people have access to that site.
Right, but I mean, that's your responsibility. You grant
know.
other people, that makes you responsible for their actions. It's pretty,
I know, and I said 500.
Yeah.
I would go along with 1,000 now, having he said that, but I will just, for the inconvenience of coming over here and all of that, I'm going to impose a fine of $500.
Okay, Your Honor. Thank you.
Okay, therefore, in case number 9, RTL 01-2407, I find the respondent Kimberly M. and Bruce W. Woodburn to have been in noncompliance of Article 4, Section 4.1.a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 1225 Sunland Road, and to have subsequently come into compliance. Mr. Yates, do we have a date?
yes, November 7th, 2023.
November
2023.
November 27th, 2023.
Sorry, 7th.
No, November 7th, 2023. And hereby order, the respondent shall pay a fine in the amount of $500 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. I would like to add that I am making I'm rendering this decision based upon Mr. Woodburn's demeanor and the fact that a matter of this has not occurred before. But if this starts to appear with regularity, and I'm not speaking to you, but I'm speaking in other matters, that I will have to question whether or not there are other people who have access and are in fact bringing the site, reviving the site, despite the fact they shouldn't be doing so. Is that clear?
Yes, sir, it is.
Okay.
Thank you.
Thank you.
And 116 Bellevue's ad is now down, if you wanted to rehear them.
The one on Mr. Ramirez? Why
Yes.
don't we have Mr. Ramirez come back here if he's here? Okay.
All right.
All right. This is a continuation of case number 4, RTL 01-2401. Respondent being Carlos Ramirez for the property at 116 Bellevue Avenue. Mr. Ramirez, you're back before us. Does Mr. Ramirez need to be resworn? Okay. You have been previously sworn?
Yes, Your Honor.
So where are we now, Mr. Yates?
The site has now been taken down. He came to me about 10 minutes into our recess and let me know that he had taken it down. My only concern is that that was rather quickly for someone who had no knowledge or control before today of that.
Okay. Well, Mr. Yates, what is your recommendation regarding a fine in this matter?
Still 15,000.
15,000, okay. Now, the original advertising, was that on VRBO?
No, it was on Airbnb.
Okay, so he took that down immediately.
Yes,
That was the
absolutely.
one I was aware about.
Okay. And if he had done that on Airbnb and that there was no VRBO, then you would be seeking
$1,000. Yes, sir.
Okay. The VRBO listing,
Mm-hmm.
were there rentals that occurred after October 6th?
There are no reviews on that one.
Okay. And so that is consistent with Mr. Ramirez's statement that he was somehow unaware.
I don't see how that would be consistent with that. That just means that
Well, then
there were no
nobody posted
reviews.
it. I know,
It doesn't really mean that.
Okay. But if there were, that would be,
The unit's never been rented.
okay. And Mr. Ramirez, the unit was under construction?
Still is.
And so, under these, Mr. Jackson, yeah.
The posting itself, it wasn't a different property.
No. Same property. It's just that it was up on two different sites, and I wasn't aware of the second site until last Thursday.
I wasn't aware.
One was clearly being advertised, even though it was not quite big.
Seeing as this case does have some unique qualities to it, we would be willing to revise our request to $5,000, but not any lower than that.
I just don't understand how the previous gentleman actually rented it and violated and collected money. I have never rented. Soon as I was made aware, in order to take this one down, I actually had to humble myself, call the other person, and offer to pay him because we ended on bad terms because I didn't think he was doing a good job. So now I have to pay him money for a job that he didn't do, and he didn't complete, and he didn't check the laws in order to get him to take it down.
Mr. Ramirez, I'm going to take you at your word that you were not aware of it. And in such situations where you take action rapidly, as you did with respect to the Airbnb, it would be a $1,000 fine. And that's what I'm going to levy.
Thank you, Your Honor.
All right. All right. In case number 4, RTL 01-2401, I find the respondent Carlos Ramirez to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and damage to surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.09 1D, Florida statutes for the property at 116 Bellevue Avenue, subsequently come into compliance on January 23, 24, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes.
Thank you, Your Honor.
Okay, thank you. Mr. Yates, I would suggest that in the future, when the people contact you, that you indicate that they are going to be aware of any and all postings, including those that you are, and that the burden falls on them.
I make them aware.
Okay.
Your Honor, he clearly did. 100%.
Okay, I understand that. You again, I'm operating off of your demeanor, and I have the ability to try to assess whether somebody seems truthful or untruthful. And so I appreciate the speed with which you took it down and got this matter resolved.
Thank you, Your Honor.
Mm-hmm.
How do I pay this fine?
Excuse me?
Okay, thank you. Have a great day.
Case number 5, RTL 012402, Islam Esmat Antar Farghali, cite for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.8.2 at 1014 Essex Road.
Could you state your name, please?
My name is Islam Farghali.
You're going to have to talk slower than that.
Islam Farghali.
You can
Gotcha.
push that down.
There you go.
Yeah.
Raise your right hand.
Yes.
Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
Thank you.
No problem.
Okay, Mr. Yates.
The case before you was a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed October 6, 2023, and they were notified the same day. The property stopped actively advertising as of October 9th, 2023. The daily posted rate was $48. The advertised rules showed a maximum of 3 guests and no smoking. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Mr. Farghali, I'm Matthew Jackson. I'm the attorney for the city.
Sure.
I previously presented a request or a statement for the record as related to determining whether or not these are irreparable or irreversible violations to the magistrate. That's something I can present again if you desire for me to present it, if you did not hear it the first time.
I heard it.
Okay, is it something you need me to present, or is it something you would waive hearing again?
No, I think I heard you earlier.
Okay, so I'm taking that to mean that you're waiving the need to hear it again.
Yes, ma'am. Yes, sir.
Therefore, let the record reflect that Mr. Jackson's comments regarding irreparable and irreversible, as he provided in case number 3 in this proceeding, are hereby incorporated into the record. Okay. Mr. Farghali.
Yes. So basically, I was not trying to rent my house. I just was trying to make an account, see if I decide later on, because I just start a new career as a CDL driver. So I was trying to see if I post like one room, because I'm not renting my house, I live there. And that's why it's $48, because my house is 4-bedroom. And I didn't finish even the complete account for Airbnb. And as soon as I get the notice, I take it off. Plus, when I search it on Google, I didn't see anything that says it's illegal or it's violation to rent one room in your house while you're staying there.
Mr. Farghali, your posting is on a short-term rental website.
No, it's not on, sir.
Well, it was.
Yes, it was, but I said I removed it that same day.
Okay.
It was intentionally, but I was not going to do it. I was just creating the account.
But you removed it after you were notified by Mr. Yates that it was there.
Whether if I got the notice or not, I was going to remove it because I didn't even completed the procedure for the account. I didn't even put the account or how I get paid or anything like that.
Again, we're pushing the envelope there that there's a advertisement which is posted, and yet there is a statement that you were going to undo the posting, and I'm finding that kind of hard to reconcile. Mr. Yates is asking for $1,000, and that's Mr. Yates. On this posting, does this constitute a holding out for advertisement for rental?
I believe so, since you could put in dates and submit the booking.
And it has a price?
It has a price, and you see $60 at 5 nights, and it shows because I put in my dates, and those dates are considered valid.
Well, and what trips the threshold when one is it leasing or is it actually?
The holding out of itself is the violation. So all they need to do is make the advertisement, and that's enough.
Okay.
And clearly, and I know it's the format of these sites, Mr. Magistrate, but clearly, when you have check-in and check-out dates and times, you're starting to sound a lot more like
A duck. It walks like a duck.
yes, more like
Talks like a duck and it quacks like a duck. It's a duck.
like a motel or a rental, an accommodation type of rental, and not a extended home rental.
Okay, well, Mr. Fargali, my determination is that to levy the $1,000 fine. Okay, I see all the elements of holding out something for rental on a short-term rental site, which is, and the city has established as you've probably heard, we initially were seeking $15,000, and for those people who were very cooperative and immediately responded, as you did, that it was reduced to $1,000. But we go beyond that. We start getting into details that are beyond the ability of the city to determine, and things such as intent and all of that it's the action that triggers the fine, the way the fine is done, and not necessarily that something was posted without an intent. The minute it was posted, it tripped the threshold.
Yes, sir. But as you see, it was posted for $48. So who's gonna hold a whole house for $48 a night and have intention to rent the house?
I don't know.
Okay. Beside that, I might made a mistake, but I searched it. I didn't see anything says this is something violating. And even if there is, and I did that mistake, I believe I shouldn't get disciplined for paying $1,000. Especially, I didn't get rented. I didn't get review. I haven't had anything come in my pocket from the property.
I don't know that. I don't. The city has no. And Mr. Yates, does the city have any way of knowing the transactions and things?
No, absolutely not. No, all that would be private information.
Okay. No. No, I think in this situation, the fact that you had posted this but that you did take it down, puts you in the category of those people who responded quickly and appropriately. So therefore, in case number 5, RTL 012402, I find the respondent, Islam Ismat Antar Fargali, to have been in noncompliance of Article 4, Section 4.1a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. And such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs time the violation occurs and cannot be undone as provided for by Section 162.09D Florida statutes for the property at 1014 Essex Road, and to have subsequently come into compliance on October 9th, 2023. Am I correct? And hereby order respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again. And that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Is there a way I can extend the payment instead of within 30 days? Because I cannot pay it in 30 days.
Mr. Jackson, there appear to be two ways. One is that this becomes would I be correct, a lien?
That's correct, yes. After 30 days, it would be, the city would.
I'm saying I'm willing to pay the 1,000, but I'm saying can I pay it within 90 days, for example? Because I cannot pay it I have too much bills coming up. I have property tax. I have payment coming, a lot of payment.
Yeah, unfortunately, we don't really have a mechanism for tracking it on this periodic payment. So, but understand this, that if
With
it's,
IMS now, Tony.
Oh, we do?
He could go in there and
Okay,
like
well,
make a payment
person who
of
handles it.
$500. And then in 20 days, if it's okay with management, so you need to have that conversation, you would be able to make payments now.
it's okay with management, with management.
Well, with the compliance administrative staff and the legal staff to extend due to a hardship, that could be discussed.
Who would be his point of contact?
That would be Denzel.
Denzel Washington?
No, Denzel Sykes.
Denzel Sykes, I'm sorry.
We're not laughing at you.
Sorry.
The code compliance manager who isn't here today, he can work with you if you have a hardship.
Yes, but it's only for paying the tax, the property tax, so I have a lot of payment coming.
Yeah. Yeah, you can meet with him and discuss that with him.
So-
Sorry, Tony, I just didn't know if
Send me
you
a
knew
request, I'll
IMS
give you all
did
his
that now.
information. You have my email and stuff?
Yeah,
Yeah, just send me a request, I'll get you all of his contact info.
okay,
There you go.
all right, thank you.
Okay.
Sorry, Tony, I didn't know if you knew that through IMS, they can put how much they pay now.
Know very little about IMS at this time. It's our new system.
And I have to stop watching movies.
Do you know about Denzel?
Okay.
Sorry.
Case number 6, RTL 01-2404, Cindy Lee Niles is cited for failure to correct violations of Land Development Code, Article 4, Section 4.1A, Article 5, Section 5.2.8.2 at 1045 Chaffee Place.
Could you state your name,
Morning.
please?
Cindy Niles. Good morning.
And,
Good morning, Attorney Walter Snell for Ms. Niles.
Mr. Snell?
Good morning, sir.
okay, I'm going to swear in Ms. Niles. Yes. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed October 20th, 2023, and they were notified the same day. The property stopped actively advertising as of October 24th, 2023. The daily posted rate was $85. The advertisement displayed 126 reviews. The advertised rules showed a check-in, check-out time of 3 p.m. and 11 a.m. This is the second case for this owner at this address, the first being RTL 11-21-226 on November 30th, 2021. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, and this being the second case, the city is requesting a fine of $15,000.
Okay. Mr. Jackson, do you have anything to add?
Yes, Mr. Snell, Ms. Niles. I've previously presented to the magistrate the city's position as it relates to irreparable, reversible in nature determination. I don't know if you were present, Mr. Snell. I don't remember seeing the other.
I was,
Okay,
yes, sir.
great. And Ms. Niles as well. And I don't know if it's something you'll feel I need to.
No, sir,
present
we
again.
would stipulate that
Okay, and if
we
there's
both
something-
heard the
Yep.
position.
Okay, I don't think I need to say anything else.
All right, the parties stipulate that Mr. Jackson's comments regarding irreparable and irreversible as provided in, I think that was case number 3, RTL 102369, are hereby incorporated into this proceeding. Okay.
Oh, I'm sorry. I said I didn't have anything else. Just the only other thing is that, as I've stated in the past, as it relates to the fine itself, historically, our request is that if it is a repeat violation, someone who had been previously found to have been in noncompliance on this type of violation, we would be asking for the maximum fine, which is the $15,000 fine, based upon the gravity of the violation and the fact that it is reoccurring, and showing the efforts of the respondent in terms of failing to comply.
Okay.
I have nothing further.
Nothing further. Okay. Mr. Snell?
Yes, sir, we'd just like to offer some mitigating circumstances, and I'll preface it and have my client testify. She's been a resident here since '79, owned this property over 25 years. Typically, she has looked for roommates, which provide her, one, some additional income, and two, some security. Having someone else in the home is a benefit as she otherwise lives alone. She had a roommate for the 7 years. That roommate left about 3 years ago. That's when she first advertised on the Airbnb through her daughter, who helps her understand the listings and whole procedures. She's not familiar with it, as many other people that have come before you. So in that first case in November 2021, when she got the notice or realized what was going on, she immediately complied, took it down. In the current situation, she was out of the country in October for about 3 weeks. The notice came in when she got home. She had no idea what it was about because she'd been out of town. Asked her daughter because she was looking for another long-term roommate. Her daughter was aware of that. Her daughter does advertise for other people who are in areas that allow these type of short-term rentals. She explained that someone had reached out to her through these other ads looking for long-term. They connected. She said, by the way, my mother has a basically looking for a roommate. The gentleman agreed. The daughter opened up the Airbnb listing for the purposes of him to pay the first month in the security. The gentleman did end up signing a 1-year lease. I have a copy of that I would offer to Mr. If I may approach, I'll offer you a copy.
You can approach.
November?
So
after.
The arrangements were made through the daughter. Airbnb was the conduit for which he made that first payment. Comes into town and signs a 1-year lease. He's still there now. All subsequent rents are paid through to her directly. And as soon as their daughter told her that this is what she had done in order to accommodate this, it was immediately removed. At this point, I'd ask Ms. Niles, I'll ask her to confirm some of these statements. Put you under oath.
I swore and didn't.
Oh, okay, I'm sorry. First of all, you heard what I've represented to.
Yes, exactly correct. And I tell you, I was so nervous when I was here last.
And I'm sorry, I would ask if you can go to the mic.
Oh, sure.
Yeah, we don't have the center like.
I live on a teacher's salary. I own a post-secondary vocational beauty college in Florida, and I do have some rentals above my building. I was so nervous when I left here 2 years ago. I was like, oh my God, I stand to get a fine of $15,000. Trust me, I've been in compliance ever since. I'm so happy to have this 1-year tenant. It just helps so much, Your Honor. I can't tell you the taxes on living on the river and the expenses of the insurance after the last hurricane.
Let me ask you a question.
Yes, sorry.
With these current circumstances.
When
were you out of the country? Do you
I
know the dates?
left October 1st. I didn't come back until, I think my flight was October the 28th, but I can verify that.
That's fine.
Oh, I
When you
wasn't.
came home, did you find this notice?
Oh, yes, it was
dated October 20th?
in my mailbox, yes.
And were you aware that there was any listing of your residence?
Oh, absolutely not.
And how did you finally come to realize that it?
My daughter called me and she said, Mom, what would you think about a year guest? I said, well, let's interview him. That sounds like a great idea, Burgundy.
Did she indicate she had opened up Airbnb?
Yes,
for the
she
purpose
did.
of this
Yes, she did.
Accommodating this initial.
And would if he wanted to do a year's lease only. That is correct.
And once you told her about the violation, she immediately.
Oh, yeah, absolutely.
And this tenant is still there?
Yes, yes, he is. Yes, he is. I hope not to lose him, which I don't think I'm going to. There's so much construction going on at the lot next to my house. It's noisy as heck. But anyway, that's a whole nother situation.
And you and I had spoken to your daughter about this to both understand his background. And of course, her being here today would have been helpful.
It would have
even
been.
though kind of putting the blame on her, as other people have. Why was she not able to be here today?
My granddaughter died today. It's her birthday, so we're kind of a mess.
You and I both asked her to come, and of
We
course,
did.
she was just unable to. And
Mentally.
where she would be offering these statements to the panel.
Absolutely.
You know, we just asked the court to consider, under these circumstances, it certainly wasn't a knowledgeable thing. It wasn't something that was intentional, trying to thwart, the goals of the city. She's been a long-term resident. She runs another business, which is on the agenda, Cindy Lee Nails and Salon, which is right on Peninsula near Seavers Boulevard. So her status here in the community for over 30 years has been full compliance. This was something unbeknownst to her, once discovered, immediately removed. we'd ask you to consider something less than the full maximum fee that is being recommended.
42 years. Mr. Jackson, this raises the question as to what is the underlying violation. Okay? If I understand correctly, the city's land development code prohibits short-term rentals except where they're allowed.
That's correct.
And we have had a parade over the years of people who use the Airbnb and the VRBO sites as a means of obtaining those short-term rentals. Long-term rentals are permissible. What happens when someone uses a short-term rental platform to obtain a long-term rental?
The problem is the one I mentioned in the prior case, which is the format of that platform is a format that speaks short-term rental language. It says things like, I thought it was up already. It says things like check in and check out and restrictions and the things that would say that, hey, this is short-term rental. It provides the means, and that's what an advertisement does. It provides means. It doesn't necessarily do exactly what we're saying it does. We don't have a way to know what it's going to do, but it's holding itself out that what we can do is short-term rent, which is a violation of the code. Our code under section 5.2 under principal uses has a note. It says the other accommodations and uses include all uses regulated by the prior LDC as accommodations, other hotels, motels, rooming homes, houses, bed and breakfast facilities, or RV parks, etc., or i.e. Rental units intended to be used by transient persons or tourists for overnight or short-term lodging. This use thus included and continued to include vacation rentals as defined in Florida Statute 509.242 and grandfathered from the 2011 amendments to Florida Statute 509.032 sub 7 that preempts local government regulations of vacation rentals in accordance with the provisions of that statute. The provisions of that statute, if we walk through those provisions, and I'll make this available to Mr. Snell, we walk through those provisions. The provisions of that statute use the terms of guests on public lodging establishments, and in that, it says that transient public lodging establishment means, and it gives its definition, but included in that definition it says, well, I'll read the whole thing, it's not that long, means any unit, group of units, dwelling, building, or group of buildings within a single complex of buildings which is rented to guests more than 3 times in a calendar year for periods of less than 30 days, or 1 calendar month, whichever is less, or which is advertised or being held out to the public as a place regularly rented to guests. There are a number of other references to that holding out, and we have numerous references in our code to the prohibitions to holding out regarding something that is prohibited by the code. And so that's the problem. The problem is, once it's up with that language, it's being held out. What they're actually going to do, we don't have that answer. But what we do know is it's being held out to allow that which is prohibited by our code. And that's what we're enforcing.
So what in that advertisement would be considered holding out as evidence of someone seeking a short-term rental?
Well, I guess
I think Mr. Yates, or you previously had is there a per night?
Yeah, per night's 85 with a minimum night stay of 75 nights.
Okay, is there anything on there that says we are seeking, or I'm seeking someone?
No, nothing that says long-term. We want long-term. It only specifies regular Airbnb. That's even, it's really not a site used for year-long. That's why you can't even set it to do year-long rentals. Can't even set it to do 6-month rentals. It won't allow it. Because it's not designed for it. Because you're advertising your short-term rental on here.
Mr. Yates, I'm going to throw a hypothetical out at you. Let's say somebody was looking for a short-term rental, and somebody came along and said, I really like this place, I'd like to rent it for a year. Is that possible?
Well, it's possible, but once again, the violation is in the advertisement, so we need to not go that far. We need to focus on the fact that if it's up, it's violating.
Well, I'm saying that there's nothing in the advertisement that says that I'm really is there anything?
Yeah, you can't,
I'm looking for someone on a long-term basis.
no, nothing that says that. And I mean, once again, there would be more room for leeway in a case that wasn't a repeat offender, but being that it's a repeat offender, a lot of it goes out the window. You know, you were told, don't use Airbnb already. You were told, don't be back on that site. But here we are. And it wasn't until they were caught that it came down.
Do you have any idea how long it was up?
I can't say before I found it.
Okay, were there any reviews on it or anything of that nature?
There are some reviews. No, there's 126 reviews total.
But some of those go to the previous?
Yes, because it's reactivated, because they activated the same advertisement that they were told to delete. Instead of deleting it, they reactivated it.
Are there any reviews that are subsequent to the time period when it was?
I did not see a recent review.
Okay.
And Mr. Vigil, just for sake for Mr. Snell, just wanted to provide him with that.
Thank you.
Trail of advertising provision.
Thank you.
Well, sure, we were trying to offer what we did in mitigation. I mean, it was up, but you can see on there that it wasn't up seeking the short-term rentals. It shows minimum 75 days. Check-in date was April of 2024. So it was an old listing reactivated for a very limited purpose by her daughter without her knowledge. But yes, her daughter's helped her in the past. The previous violation was certainly a wake-up call. There's nothing subsequent. One, she can confirm there was never again any short-term rentals from that first violation, and her goal was looking for a long-term roommate, which ultimately she did get. The rental lease shows it's a roommate situation. So it was up. Once she came home, realized it was up. Oh my God, how did this happen? Her daughter explains it. You know, the transaction is made and it's immediately removed. Daughter is forever apologetic because she's caused it, but I mean, that's the best we can offer. It wasn't intended to seek out and thwart the city's goals.
Also,
Been a compliant citizen for 40 years.
Just to point out a little issue with the timeline, she's saying she was unaware, but yet it was removed on the 24th. So she's saying she didn't become aware of the 28th, but yet they're notified on the 20th, and then it's removed on the 24th. So parts of that timeline don't quite work.
October.
Yes.
I wasn't even here. I wasn't.
Like I said, so somebody became aware.
Oh, sure.
And then removed it, but then would know that they were in violation and didn't tell it. It's a little fishy to me.
Well, we'll say I appreciate that they're not saying it's not up.
Yes.
So we don't have that situation.
Not up and hasn't been up since I left this courtroom.
The daughter gets her
Well, no, it
mail
was
while
up.
she's gone.
It is up. Yeah, I appreciate that they're not saying it's not there.
Yeah, we're not-
Because we're all seeing it. It is posted.
Sure. And
So our real issue is just where
we're
we
offering
are.
mitigation as to why it was up for this brief window. Not by her, certainly her daughter. We're not trying to throw her under the bus. We're trying to help her to find a long-term roommate, which ultimately she accomplished. The daughter got her mail while she's gone. And when she comes home, sees it, and the daughter, oh, by the way, this is what happened. Immediately rectifies it, because now mom is pretty upset and like, how did this happen? Why am I gonna go back? So it's all being offered, sir, in just mitigation. It's not something she's trying to.
But before you said that you came home and then you deactivated it, but that is what you said earlier. I'm not saying it's true.
Sorry, Mr. Yeager.
Yeah.
I didn't
It was deactivated.
It was deactivated.
She doesn't
Right.
set it up and didn't deactivate
But
it.
that is,
But we can clarify that if need be in testimony, but, you know, the person who brought it up took it down, but yes, it's her daughter.
Am I correct that the tenant is agreeing to pay $1,350 a month for a bedroom and a bathroom?
Yes, he is. It's right on the intercoastal.
that's pretty, you can't get a one bedroom for much less than that right now.
And it's got, yeah. Thank you, Mr. Yates.
Yeah, no, it's not a bad deal, especially for the location.
Do you want to rent there?
Well, roommates are always very risky. I have a lot of
Yeah.
clients come to me looking for roommates for the financial benefits, and 50% of the time they don't work. And it's really a difficult thing to find that balance. So to have somebody there 7 years was a blessing because
Yes.
they got along. Bringing somebody else into your home is always a crapshoot, and there's best you can vet these people. But that's the goal. Having people come and live with her, intermingle with her on a short-term basis is not practical. The goal is trying to find, again, a solid roommate that'll be around for a long time. Provide those two benefits, a little extra money, competence.
I'm having a very difficult time with this, as you understand, because we're starting to go into away from objective criteria and going to subjective criteria that involve things like what are other people's intent, including people who are not even here before us today. And obviously, I understand, Ms. Niles, that you had room in your place where you live, and you were looking for someone to be providing assistance and, I guess, paying costs and things of that nature. And on the one hand, the argument has been stated that your daughter posted this with the idea of trying to obtain a long-term rental.
Or if I may clarify that point.
Okay.
The daughter helps other people do these in locations that are valid. But through those other ones, somebody reached out. She says, by the way, my mother has this opportunity. So this particular property wasn't advertised for the purpose of finding a long-term roommate. The daughter opened it up, having found this gentleman who connected and found to be a good opportunity. And through the Airbnb, the transaction was done for a first and last month's rent. So it wasn't seeking a roommate through that listing. That's the way I understand it is.
Yes, that is correct.
It was a mechanism for the initial deposit and first month's rent as the method that this person was familiar with through the Airbnb platform. Once that initial transaction is over, he comes into town, they sign a lease, and all future rents are paid to her directly. So the only clarification is it was not open seeking a roommate. It was open to handle the financial aspect. But yes, it was open. It was there when you saw it on October 20th. But the ad you see isn't consistent with the typical short-term rental opportunity.
But doesn't Airbnb charge for
Yes, sir.
basically
Yes,
acting
sir.
as a middleman in something like that?
Like 17% she would have paid on those 2 months for no reason? That doesn't make much sense.
I mean, she found, and I'm just trying to understand, your daughter found this person, but it was outside of Airbnb.
No, sir. My understanding, it may have been through her other Airbnbs, because she does assist other people who advertise in areas that it is allowed. So through those other ones, my understanding is there was some question of, hey, is there anybody that has a potential long-term rental? Oh, by the way, my mother does. They have this communication, and the Airbnb is open because he says, I can pay to go ahead and secure it through Airbnb because many people are familiar with it. They use it all the time wherever they travel. So it was a mechanism to secure the place and pay that first month's rent security deposit. Comes into town, signs a lease, and everything in the future is directly to her. So the ad wasn't posted for seeking a roommate. It was to handle the initial transaction. Yes, there's a cost, which is why everything in the future is directly to her.
So if I understand, her daughter is is it Airbnb?
Yes.
Yes, sir.
Yeah,
Yes.
okay, Airbnb, and somebody says, do you know about a long-term rental? And then she says, yes, and then, well, I would like to go through Airbnb to put things like deposit and all of that.
Yeah, it's a little odd because the buyer also wouldn't get protection from Airbnb because then you'd be doing something outside of Airbnb, even though you collected the money that way. There's no way to set up on Airbnb, this is for the first month, this is for the last month. You'd literally have to set up a booking, give it a nightly rate, and then tell them, oh, can you put in 8 days, and the 8 days will charge you your first and last month's deposit. Like, anything's possible, but in this case, I really think we just need to focus on the fact that the advertisement, because that's what we know.
I mean, I'm looking at this, it would be one thing, but Ms. Niles, you previously were cited for Airbnb, for this type of activity. And now we have someone who is doing something I've never seen before. I don't think, Mr. Yates, have you seen anyone do anything like this before, where they try to
No, because
use a short-term rental platform to effectuate the terms of a long-term lease?
Right, you'd lose the protection the website offers, which is why you book through them. And then on the other end, the owner of the property is giving away 17% of their money. From neither end, it doesn't make sense from either end.
Yeah. I've heard of situations where people have met over Airbnb, and then that has blossomed into a long-term rental. But it was always, how quickly can we get Airbnb out of the picture? Because that's money in my pocket as opposed to money in Airbnb's pocket.
Which is why it was limited, sir, in this case to, I don't know whether it was
One day.
Well, was it a security
No, it
deposit?
wasn't 1 day. It's 75-day minimum, that's it.
No, I mean, when the listing was up, because all of this is old.
Well,
This is
do you remember how much was paid through Airbnb to secure it? Was it a first
God.
month rent only, do you know?
I believe that in security, but it was after I came here, before, you see what I mean, when I was here?
Back to the mic.
There's been no, sorry. There's been no guest in there since then. Everything you're looking at is before that year that I came up here, which was, what, Mr. Yates, November 25th, 2021?
You understand those are prior.
Yeah, okay.
But yes,
I
it's.
wasn't soliciting an Airbnb guest, that's a fact. I don't want short-term rentals in my home. I've lived there for, let me think, 1997 to now, so what is that? I don't know, 25 years?
But I will say that there's also no long-term rental license on file for this property, and it's located in a single-family zoned neighborhood.
Right, but I can have a roommate, can't I?
You can have a roommate,
Okay, good, that's what he is. He's a roommate.
This is her permanent residence.
but you have a lease,
I do.
and you have first month's rent,
Yeah,
second
I
month,
do.
it's, you know,
Yeah,
a
you're right.
roommate would be sharing
Right?
expenses.
Yeah, we do. Thank you. Thank you.
I don't know, sounds like a rental, but that's a different discussion, different time.
It is.
But right now, what do we have right, as far as the position of the city is? We have an advertisement. And I don't think there's a big debate about whether or not there's a violation. I think the question is whether it's a $15,000 violation versus something less than that.
That's all we're asking. These were offered as mitigation. It wasn't intentional. It's not intent to get around and do something and try to fly below the radar. Like the decision is yours.
Well, I'm just having a problem with I mean, it would be one thing if you were somebody who had done this and not been found to have been engaged in advertising online before. That's the problem I'm having. You know, there's a difference between somebody who simply just wants somebody to be a roommate or in a house, but there was a previous instance where this premises was considered to be one that could be rented out on a short-term basis. And it was then advertised on a short-term platform. And now I have a lease, but it's I mean, I'm trying to look at what I would call the elements of what constitutes a violation. And so far, I'm checking all the boxes for a violation. And I don't know whether there is additional evidence or what have you that would, but simply to have a short-term rental advertisement reappear and the statements that you needed assistance in terms of trying to meet expenses, that short-term rental advertisement is also consistent with someone actually seeking short-term rentals, who would then provide assistance with the payment of the bills for the home or the unit. And so it's not like there's a clear intent to do something, and in that someone is going through a online service that charges a fairly hefty rate to do things that could have been done much simpler and without all of those rates. It just I don't know, it just seems very highly unusual. And
once I left here, Your Honor, I was in complete compliance. I mean, honestly.
I'm not questioning that.
I'm just saying.
I'm not questioning that, but you had shown an interest in trying to rent out this unit at one time through one of the short-term rentals. That's why you were here the last time. So I'm just, and then it suddenly reappears. And then we have a very unusual situation where someone is making arrangements for a long-term lease on a short-term platform and using that as a means of exchanging money. There must be easier ways to do it, and cheaper ways. It just, it pushes the envelope.
So I think, some people who use Airbnb a lot, I do not. Other people use it wherever they go and find it to be very beneficial and easy to use. So apparently her daughter and this gentleman are more familiar with it than she is, and they found it to be the best mechanism for the initial payment, with everything thereafter going directly to her. So, in a sense, it was done without her knowledge, but for her benefit, because her daughter knew she was trying to find a roommate. And it was only open for the purpose of the financial transaction, not seeking a roommate short-term situation. So other than her daughter coming here on another day and offering that same position, whether taking the fall, whatever you want to call it, she would be reiterating what I'm saying, in that her mom didn't know, but ultimately benefited from that engagement through that platform by finding a roommate that so far has been beneficial. So again, it's just offered in mitigation, hope that you would consider something less than the recommendation of the 15.
There is one other thing, and that I'm considering, and that is that the violation occurs at the time the holding out. And in this instance, and correct me if I'm wrong, Mr. Yates, there is nothing on the website that would indicate that there was ever a transaction that occurred.
No. But we would only know about a transaction if he creates a review.
That's true.
But we can say that the lease happens after they're caught. That's what we know for sure. And that it's dated in November and that they were caught in October. So it's possible it was leading that direction. A million things are possible. All we have, though, are the facts in front of us.
And certainly, there doesn't appear to be any reviews from the first time through this incident. It wasn't doing this under the radar and finally gets caught. It was learned a lesson from the first time. It's something that she was unaware of, but
I got great advice when I was here last. That's what gave me the roommate. I was like, wow, I don't want this to happen again.
Again, as I see it, the evidence as provided by the city checks all the boxes that there is a violation. And at this point, there is testimony that this was done for another purpose, and I'm having a hard time with that. And there is a lease, but Mr. The gentleman who is here, who's mentioned in the lease, it could be anybody. I'm looking for something that would say that it contradicts the simple version that this was being advertised on a short-term rental. And I'm not seeing something that rises to the level to convince me otherwise.
So again, the ad does say minimum 75 days, which is not typical of people seeking short-term, and it said doesn't even start until April of 2024. So here's it, that's not consistent with what I've seen in prior listings. People are looking for that weekend, monthly thing. This is kind of an unusual situation. And my guess is 75 probably was potentially put in to get to the figure, maybe to equal the monetary amount that they were seeking to get the lease started.
Miss,
So,
Mr. Yates?
Yes, sir.
You've been involved with long-term rentals.
Mhm.
Isn't a long-term rental 6 months in a day?
Yes, sir.
So 75 days is still a short-term rental.
Yeah, you actually don't have the ability on Airbnb to make a stay that long because it's not designed for that.
But even, wasn't it stated on that it was 75 days?
Yes, 75-day minimum.
But that's still a short-term rental.
Correct. That's sort of our point.
And although, if I may, Mr. Magistrate, although Mr. Snell mentions that it doesn't start till, at least on the advertisement, doesn't start till April of 2024, this lease agreement is the lease agreement to start
2023.
November.
Of last year.
He's been here. He's still there.
Okay.
Yeah, he's my roommate. Came in November.
so again, I would only offer that it wasn't put up for the purpose of finding someone. So dates are filled in presumably just randomly because it was open for a sole purpose of a financial transaction to get to this lease. So
Mr. Snell, you can't argue that the 75 days, it should be read as a long-term and then say, well, the dates don't, and then also argue the 75 days doesn't mean anything.
Well, it's certainly
you're
still
contradicting
short-term. I agree with that. It's still short-term. The ad was still up. Again, we're not trying to contest it. We're trying to offer that the intent, for whatever it's worth, wasn't seeking short-term rentals. It was for a purpose. But yes, it was up when he found it. It was immediately removed, and it was being expressed for the purpose for which it was up. And that's all we can offer. And the ad is a little inconsistent with what we've seen in the past, what I've seen today, and just people looking for those short-term rentals. So I don't know why it was done this way. If we continue and bring her daughter who can explain it further, but I think the facts would be the same. So we're just offering that as mitigation, sir.
And just for a point of note, while it's understandable and well expressed why the daughter is in here, I'm not sure why the tenant can come explain what Mr. Snell is explaining to us, if that was the circumstance. I mean, not that I'm saying it's not, but I don't have anyone that can tell us that it is. The tenant apparently is staying right here in Daytona Beach, seem to be seemingly available to come and say, we understood that this was the nature of our agreement, because it doesn't tell us on the website that it's the nature of the agreement. We don't have anything that tells us that it was understood that this was what was happening. And again, I have great respect and in fact, friends, Mrs. Snell. But nevertheless, nothing tells us that this is a circumstance that's anything other than what it's showing, what's being held out, what's being advertised. This is a short-term rental. And so our next question is, well, now that we know that it is indeed a short-term rental, what's the impact of the fact that this was previously determined to be a short-term rental and was brought into compliance with the understanding that this is what short-term rentals are and you can't do it. And it's being done again. And, what's the intent in their hearts? We don't know those answers. And you're trying to read them as best you can. You've been doing that all day the best you can. But we don't know the answer of the intent of their hearts. All we know is what we see. And what we see is that this is being advertised as a short-term, in a short-term rental format, which leads us to say that you're holding it out for someone, whether it's the person that you ultimately got or not, you're holding it out for someone to say, I want to come in here and be in a short-term rental. And we don't have anything that tells us anything other than that.
Mr. Jackson, would it change the city's position any if Mr. Rowe came in here and testified. I mean, I understand, and we're also dealing with third-party statements, hearsay. You know, your daughter did something, but we haven't heard from your daughter, and her intent is coming through someone else. I mean, this is all, basically all inadmissible hearsay.
Well, we're in an administrative proceeding, so.
I know we are,
yeah, so
and I
I'm
know
okay
that
with
there's
it.
a point where you can stretch hearsay beyond believability.
Right, and that's really the issue.
And you want this testimony to be believable. And I think I think that you're sort of articulating, my concern is all of the relevant things that are being stated today are all things that should be testified to by others who actually have firsthand knowledge of what transpired.
I will say, I don't think it changes the city's position. I mean, but, you know, it's weight of evidence, and it's your ultimate determination, and I mean, would it affect you? It very well may, but I just want to make the point known that we don't hear from anyone that's saying different, and I think our biggest challenge here is that, okay, we know for sure, and again, we're still trying to prove that it's a violation, which is not our real dispute. It's not really in dispute. Why it's a violation, I guess, may be the discussion, and I don't know if that's necessarily something we have to determine. The impact, the efforts being made, or what was being done, may be part of how you weigh ultimate fine of the maximum. We're saying that it should be weighed based on past history.
I think the testimony or the argument that's being made is it is an unintentional violation. It's a violation, but nobody meant to do it. And that is...
Yeah, I'm playing semantics in that. I think they meant to do it. It's just that they didn't mean for it to have this kind of impact, is what they're indicating. I mean, they meant to use Airbnb, they meant to post it, and they meant to make it and put it on a website. I mean, that's my position, Mr.
Sir, we've offered that it wasn't her intent, but sir, yes, it's her daughter, so we're not here. I mean, her daughter did it, believing it's for her benefit. You didn't instruct her from Europe to go ahead and do this. Once she realized it was done, she understood why and how and who, and remedied it. So if you believe the testimony, certainly I've spoken to the daughter to understand myself, and I'm relaying what she told me for whatever that's worth. If you believe her testimony or the tenant's testimony consistent with what I'm saying, those facts would have some bearing on your decision, and we could continue it. If you take the facts as they were, would it change anything? It's being offered again in mitigation, sir.
I think in the other sense...
I agree with that.
Sorry.
And right now, I'm trying, when you said, if you believe my testimony, you can't testify. It's her daughter. And
It's
the
what she
tenant.
relayed to me, but I understand it.
And I understand, and this is an administrative proceeding, and it's not the same thing in terms of, we try to get things done a little quicker, I think, but we still want to be able to hopefully get the right answer at the end.
Well, if the court believes that would be, this panel believes that would be beneficial, we are next on this docket. That is a case that is going to be continued. I've spoken to Mr. Yates and it's her corporation, unrelated property, unrelated circumstances. So if you feel like hearing from either the daughter or the tenant to kind of verify these facts that I have proffered would maybe help the court in lessening the fine, because that's certainly a very severe penalty. And I understand the purpose of it, but if it would have some bearing on your ultimate decision, we would offer to come back with one or both of those people confirming what I'm relaying.
Is that something that you can do?
Yeah, I would do it, sir, if it would ultimately help your decision in a fine somewhere between 0 and 15. Yes, sir.
Yes.
And if it is something that is important for you to hear from the horse's mouth in requests for something other than 15, then yes, sir, I would certainly come back. And I presume the tenant would have no issue. I mean, just going to tell you what happened.
Mr. Yates, do you have something to?
Oh, no, sir. I'm sorry. Just waiting on determination.
you're inclined today to make a decision, get less than 15 based on what we've offered, would accept that. If you feel like that other facts would be a greater sway in a potential reduction, then we would certainly come back, sir.
And I will say our position hasn't changed as far as the city.
I'm of a mind that I think that the additional testimony of the tenant and your daughter, Ms. Niles' daughter, would be helpful to the extent of dealing with the penalty,
Okay.
the fine.
Well, we'll be more than happy to return.
I would like to hear, we've noted, the elements of the violation are all there. And now we're digging into whether or not this was intentional or non-intentional on the part of Ms. Niles.
And I've seen from, this is my first time here, so I can see from how things are going that you are mindful of those who are truly unaware, based on false representation of realtors, and it's unfortunate that these people are coming here investing in property under false pretenses, but they're all trying to comply. And again, we all want as citizens compliance and things to work. So we all agree. It seems to be the penalties. Some people continue to try to fly below the radar and play that economic game of risk versus reward. So
There's a
this is
fair
not the
amount
case.
of money to be made off of short-term rentals, and I don't fault people for trying to make money. But if it violates city code, then
Sure, and I
it can
agree
be
that,
dealt with.
but in this case was not with the intent. So
Can
I'm
I
happy
say-
to come back, sir, and provide
Yeah,
additional information and testimony to help in any way to have a reconsideration of the maximum.
Before we go forward, just one question. Who was managing your Airbnb back in 2021? Was it your daughter?
Yes.
Okay, so just so we're clear, the daughter was also aware that it was not to be reposted. So all parties did know that it would result in a $15,000 fine if this ad went back up. And the daughter will come and she'll be testifying to that she was aware too. So that's my only thing.
She would explain that she took it on her own measure for a purpose and maybe didn't understand it, if they did it for 2 days for the transaction, but yes, sir, that would, she would offer what she can about that.
Correct. And sometimes I have to look at the person and the way they testify and whether or not they're saying what they've been told to say or whether they truly are saying
I think you'll find
what occurred.
I think
So I'd like to continue this with the next hearing would be February 27th.
February 27th?
Mm-hmm.
that's okay.
Okay.
9 o'clock as well?
Is that a Tuesday? I'm sorry.
It would be, yeah, I think we'd start off with you and get
I
you
do
out.
teach. Like I said, I have
Is-
a beauty school in town.
Okay, is
And-
there a time,
If you could put me as early as you can.
well, 9 o'clock is when we
Oh,
start.
that'd be lovely, Your Honor.
Does that
That'd
work?
be great.
Will that work for you? Okay.
We're on the next case as well, so
Okay. Well, the next case as well. Okay,
different circumstances.
all right.
We're pretty much stipulating to the continuance based upon what's been discussed?
Yes.
Okay, yeah, there's some issues that Mr. Snellis brought up that we would like to look into, and we believe a continuance would be appropriate for this case.
Okay. Therefore, case number 6, RTL 01-2404, Cindy Lee Niles, respondent, is hereby continued to the next special magistrate hearing date, which would be February 27th, 2024.
Yes, sir. Very well.
Okay?
Thank you. That's all I had today.
Thank you, Your Honor.
Okay. Are we? Are we okay to go forward?
Yeah, do you want to go forward or do you want to take a break for a few minutes?
Why don't we take a break at 1 o'clock? Oh. Is there any? If there's, why don't we do this? Who is here right now?
Can I ask this question before we go there, though? Do we have any that's going to be on Zoom? Anyone holding on Zoom?
Yes, number 12.
So just one of them?
Number 16.
Okay, so we only have one that's, okay, I just wanted to make sure you understood the full count.
Number 12 then.
Okay. Why don't we get number 12 out of the way? And
They're all, I mean, I'm okay with them on Zoom.
Everybody is ready for a break.
I just wanted you to be aware of the total number available. I'm okay with them going in the order of the people who are present. If that's, I think that was where you were moving to in thought. So I just wanted to make sure we knew who was out there in the Zoom world.
let me just see who is present right now. Ma'am? Which case was that?
Case, what's your address?
I'm number 11.
Okay.
That's case 13. Okay. 11. 16. 15. 19. 14. Okay, and then we have 12 on, so we have 12, 11, 12, 13, 14, 15, 16, and 19.
About in order, other than number 10.
Almost. Is 14 here too?
Yes.
14, 15, and 16.
11, 12, 13, 14, 15, 16, 19.
19, and 12 on Zoom.
So basically 11 through 19.
So, yeah, it is. Why don't we take, how long a break would anyone like to get some lunch and things?
Oh.
It is 12:50, 10 minutes of one.
So,
Whatever needed in my office, so.
I'm ready to go.
I know you are, but we have, would 45 minutes be sufficient?
That would be probably 45 minutes. You need that much time? 45 is what he
40,
said.
oh yeah, that's plenty.
You need that much or 30?
If somebody wants to go and grab something at a,
Okay, so for their accommodation, yes, I'm forced to realize that some people may have a need for having to, well, but they've had opportunities.
how about we reconvene at 1:30? Okay?
Okay.
All right, we are adjourned or recess at 12:51, and we will reconvene at 1:30. It is 1:36, and I call to order or reconvene the afternoon session of the special magistrate proceeding of January 23, 2024. And the next case that we are going to hear is number 16, RTL 012415, Pink Sand Property Management, LLC, cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.8.2 at 439 North Grandview Avenue.
Could you state your name for the record, please?
Hi, my name is Orsolia Caruso.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Okay. Mr. Yates, can you provide the...
Can we ask Ms. Caruso's relationship?
Oh, that's true.
Managing member.
The case before you is a zoning violation. This case was field generated. The property is zoned RP. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed on December 27, 2023, and the violator was notified the same day. The property stopped actively advertising as of January 4th, 2024. The daily posted rate was $81, and it displayed 3 reviews. The check-in, check-out time were shown as 4 p.m. and 12 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay. Mr. Jackson,
Yes.
do you have anything?
Yes. Ms. Caruso, I realize that you've been here all day. and,
Yes.
I previously presented the city's position as to the magistrate as to short-term rentals, irreparable and reversible, being irreparable and irreversible in nature.
Yes, I understand, and I heard you previously.
Okay, so you waive the necessity for
Yes.
that to get into the record?
Yes.
Okay.
And let the record reflect that the respondent waives Mr. Jackson providing his irreparable and irreversible comments and agrees to incorporate those comments that were made earlier today in Case 3 into the record. Okay. Ms. Caruso?
Yes, I do not know the Florida law. I was misled by state, but I do understand I break the law, not because I wanted to, and I accept the fine.
Okay, so you're not contesting the $1,000 fine that Mr. Yates is.
I mean, I've been here all day, and I heard all the stories, and I don't think it's a point to say anything. I am from Las Vegas. We have a different law for Airbnb. I was not know any of that. State gave me a short-term rental license. I paid for the non-compliance, non-transition one too, when the city told me I cannot do short-term rental, but short-term rental in Las Vegas is less than 31 days. So I rented more, and I don't comply by Daytona Beach law. So I'm sorry, and I accept my fine.
Okay.
And I do not do it again.
All right, well, then I'll do an order and you can leave.
Thank you.
Okay, let me just read it out. Okay. Case number 16, RTL 01-2415. I find the respondent, Pink Sand Property Management LLC, to have been in noncompliance of Article 4, Section 4.1A, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and damage surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.09 1D Florida statutes for the property at 439 North Grandview Avenue, and it was subsequently come into compliance on December 27, 2023, and hereby order that respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statute.
Understood. Where I have to pay?
I will send you an
Invoice in email?
Yeah, I can send an email.
Email, please, because it's take forever for get it to Las Vegas. Thank you so much. You have a good day.
Thank you. We had one other matter that needed to be moved up, and that is case number 15. Case number 15, RTL 01-2415, John Andrew Singlesether and Ha Thu Singlesether Life Estate, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1A, Article 5, Section 5.2.8.2 at 328 Manhattan Avenue.
John Singlesether. You need to go through the microphone.
Two Singlesether.
Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
We do.
Mr. Yates, if you can present the city's position in this case.
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed December 6, 2023, and they were notified the same day. The property is still actively advertising as of today.
What?
The daily posted rate is $125. The advertisement displayed 2 reviews, and the check-in, check-out time were shown as 4 p.m. and 11 a.m. Due to the actions of the property owner and the irreparable, irreversible nature, we are asking for a one-time fine of $15,000.
You said you took it down. We thought we took that down.
I think he's checking right now. Is
I'm
that
checking to see if it's still up.
First, when I received the letter, I blocked all the future booking.
You might have blocked, but so the ad's still up though. Just because you blocked future bookings doesn't stop the ad from being up. So if that's all you're saying you did, but you left the ad, then it would still be up.
Oh, I didn't know. I thought I don't
But-
accept any booking.
Verbo, is that it? Verbo? So you didn't take the Verbo down? You took that down? You took the Airbnb down?
The purpose to be done accept
Oh,
temporary. Oh,
Okay,
But as they said,
okay.
she said she put it on snooze, that there's no more bookings.
yeah, as I said, the listing needed to be completely removed. I didn't say put it on snooze. I didn't say put it on away. I said completely remove the listing.
oh, I'm sorry.
Mr. Yates, is there any way that you can tell when they did take down the?
No,
portion?
I don't keep record of when a property's bookable and when it's not, because that can change daily.
Okay.
And I
It's
just
not
check.
something you can tell from that website?
No, that's not any information they give me. Now, you guys may have received a confirmation email or something like that that would give you that date. That's a possibility. Did you guys receive any sort of email from Air?
No, they don't.
Okay.
And I took out from the Craigslist, I took completely the list.
Allow her to get closer to the mic, please. Thank you.
Sorry. Well, I didn't really delete the listing because if I have somebody stay there and then they need to receive their deposit back or something, but I completely block up on future booking.
Mr. Yates, you can't tell when,
No.
can anyone book off of that at this time?
At this
It could-
time, you could not book directly through the site. You would have to contact the host and request your dates directly.
Okay.
So then the answer is yes, it can be booked, but not through the site.
Well, it's sort of,
So-
this is a post, would I be correct? This is a posting, says this site's available, call.
What it is it's an ad that currently you can't, what's called instantaneously book, which means that you can't select your dates and just pay them right now. If you want to talk to the owner about booking dates, there's a contact that's right under your start dates, and they can then send you a direct offer for these dates. But you cannot Instabook right now, and it's feasible that they would have been confused by that.
Okay. Mr. Yates?
I'm sorry.
Is there any way that you could, or is there anyone they could go to so that it sounds like they want to take it down, they just didn't complete the process?
I don't see there shouldn't be any reason why they couldn't contact VRBO and ask them for that date if we want to use that as the compliance date instead. That should be a date that VRBO should be able to send them an official message, but
We had a case earlier today that had been continued to allow the respondent to take down the case and then come back and hear, as opposed to I can't say I like computers either, so.
I'm sorry. I'm not real good at the computer, so I just did what I think is the right.
And if I just saw, I just said this to Mr. Yates, but I just saw, can make sure I'm correct. I think if I understood your question, it seems the question is more towards not whether or not we look at the snooze as being compliance, but that can they get some help to get to compliance because you're not sure that they know how to do it by themselves.
Get them in complete compliance, and then it sounds like they're trying to get there. They hit a bump in the road. How can you, or is there some way, somebody who can assist them so that they are?
I could walk them through the steps if they want to give me a call. Obviously, I won't access their account. That's too far, but I wouldn't mind if they called me, and I have no issue walking them through the steps.
That's fine. So let me throw this out, and that is, my preference would be to continue it and just resolve it at one time, than to sit here and say, well, you this and that and all of the other thing. And that would mean coming back, I assume, to be the next hearing date, which is February 27th.
Yes.
And Madam Secretary, if we could put them along with the other people sort of at the head of the agenda so they could just, hopefully, we could go through these, clear up these things, and get them out quickly.
And just so I can make it clear, the city's position would be looking at their diligence and good faith and moving towards getting this thing resolved as fast as they can get it resolved as far as getting it taken down. I believe, if I understand right, snooze just means it could be woken up at any time.
Yes.
So we would like to make sure that they diligently and rapidly get it taken care of.
Is that acceptable?
Yes, yeah.
Then,
One other thing I'd like to mention.
Sure.
Is that when we were first considering renting our place, we contacted the Daytona Beach tax office to see what we were required to do to fulfill their requirements. And they gave us a letter back, and it said that we weren't required to register them because we were going with Airbnb. So we thought everything would be on the up and up with that.
you're not the first person to say that you tried to contact other governmental authorities and they sort of, I hate to say, led you astray. I would like to hope that someday we get all these taxing authorities and all the other folks to say that when people come in with this type of thing and say, you may be required to register or, or it may not be permissible in your specific municipality, and at least put everybody on notice. But I mean, that's county, isn't that?
Yeah, and I think, not trying to defend the taxing authority, but I think what we've had come before us is that people are trying to at least resolve properly the tax element of it. And so that's where they're getting off. They make the contact and they're saying, hey, don't need to deal with us with that, deal with them over there. And that's a different, part of the whole picture. But the whole picture is ultimately, if it's the city that you're in or the county that you're in, probably need to talk to them both and find out from either one if you're violating anything when you're initiating a business venture.
Okay. So then therefore, case number 15, RTL 012414, John Andrew Singleselther in Hafu, Singleselther Life Estate. This matter is continued until February 27th, 2024. And that would be another special magistrate proceeding like this one.
Oh, okay.
Yes, sir.
Just give me a call. You guys have my contact, and I'll walk you through bringing it off the site, okay?
Okay, great.
Yeah. Mm-hmm. That's what we're going to ask you to do, yeah. Okay, well, if not... Okay, but if not, call me and I'll walk you through, okay?
Okay, great.
All right. Thank you, guys.
All right, we did that.
Mm-hmm.
Is there anyone here on behalf? I want to do the cases for people that are here. And so I'm going to go down the list and Case number 7, RTL 012405, CBPR Inc.
That was Ms. Niles.
We continued that.
That's continued?
That's the one we had asked to continue with Mr. Schnell and Ms. Niles.
Well, no, but they were also case number 6.
Right, remember we said that they had another case, the next
Okay.
case, and they were continuing for both of them.
Okay, so we're continuing both. I did not hear that comment, but that's fine as long as they know it. All right, so we'll now move on to, I take it no one is here on case number 10.
Correct.
So case number 11, RTL 012409, Adam McGee. Okay, Adam McGee and Jennifer Spangler, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 275 Brookline Avenue.
Present.
Okay. You have to wait a second until
No worries.
our board clerk is ready to swear you in.
Sorry. Did we get names? I'm sorry.
Yes.
Okay.
Adam McGee
McGahee.
and Jennifer Spangler.
Okay. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Okay. Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed November 8th, 2023, and they were notified the same day. The property stopped actively advertising as of November 17th, 2023. The daily posted rate was $115 and displayed 2 reviews. The check-in, check-out time were 4 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Okay.
I'm gonna find out what's up.
Mr. Jackson?
Mr. and Mrs.
No, we're not
McGahee.
married.
Oh, I'm sorry. You're right. Mr. McGahee.
Yes, sir.
And Ms. Spangler. There we go. We, I think y'all been here.
We've been here all morning, yes, sir.
Yes, and I've previously presented my comments regarding the short-term rental.
Yes, sir.
Regarding the issue of irreparable or irreversible in nature, and asking the magistrate to make that finding. You heard that. Is that something you need me to present again to the magistrate, or is it something you want to waive?
I'm okay.
We're okay.
Okay,
Can
so
waive it.
you're waiving additional reading of that, and
Yes,
and
sir.
the magistrate can consider it, and it's related to this proceeding.
Yes, sir.
Okay.
Okay. Let the record reflect that the respondents have agreed to waive the Mr. Jackson's statements regarding irreversible and irreparable as presented, and his comments provided in earlier case number 3 are hereby incorporated into this matter. Okay. It's your turn.
So Your Honor, basically, we did in fact list on Airbnb, or I'm sorry, VRBO, and we were under the impression that we could do. Did you want to talk?
Sorry. Yeah, we didn't realize that you could not advertise on them. We were asking for the maximum rental through a VRBO, which was 180 days, and they couldn't make an instant booking. They had to apply for it, and we would then tell them it has to be 181. And then the one guy that we had, he signed a lease, and he actually stayed for longer. And because I couldn't find anything that said that you couldn't advertise on them to obtain a tenant, I thought it was okay. He also wasn't a transient person or a tourist. He was here working, and he wanted to stay longer. So I live in Nevada, and I wasn't here to monitor them. So I interviewed 2 property management companies, and they all seemed very iffy. So I thought if I just used BVRO to collect the rent, and they would be a reputable person, they'd have credit, they would care about their rating, they wouldn't destroy my home. And
You
I
pay the
didn't see
taxes.
anything. Yeah, and I would pay taxes. I didn't see anything that said you couldn't advertise, so I felt like I was adhering to the rule of 181 days. Now I know, so I have taken it off. I'm not advertising through them, and I'm not renting at all.
Your Honor, I have a question. Are you guilty by association? Because I noticed we've been here all day, and it seems like everything, even if people had the house rented for a year or 6 months or, 500 days or 2 weeks, it seems like everything was brought to the fact that it was a VRBO situation. You see what I'm saying? So are we allowed to advertise on Craigslist? Can we put a sign in the front yard? Can we go on Offer Up or Facebook? You see what I'm saying? How are we supposed to have exposure to renting a property safely? When we bought this property in 2019, it was very difficult. There's a very transient in that area. It's cleaned up now, thank God. But we've had 2 break-ins for the fact that we weren't there. So the fact that we're able to rent this out and have a tenant there keeping an eye on the property, keeping it safe, not only for the neighborhood, and keeping our possessions safe, that someone's not going to be breaking into a window, stealing the air conditioner, doing this or doing that. So this is the reason why we're kind of there. So, we've had the opportunity to see a lot of different cases happening. So we're just trying to figure out moving forward, because it seems like we're guilty association no matter what. But moving forward, what is the proper thing? We also live in Las Vegas, so if we have someone come out here for 2 weeks, if we have one of our friends from New York or from Maine or whatever coming in, is that a problem? I mean, are we not allowed to have our property if we don't take any currency? Is that, you know what I'm saying? So I'm just trying to understand a few different options that we could have if the court would share with us.
Well, I can answer the advertising question. As far as advertising, there's a good old traditional advertising that tells people what you're advertising for.
Right.
Anything away from that, if you start getting into these short-term rental formats,
okay,
then they're going to at least imply that you're advertising for someone who's going to stay day to day,
right?
That they're going to have check-ins and check-outs, and they're going to have accommodations and so forth. And what you're really saying is, I'm offering this on short term. Well, you say, wait. Okay. I know you said we can do this 6 months, but we don't know if it's a 6-month person or a 2-month person.
True that.
So it's been held out on a format that allows someone to come in and rely on that as what they're coming to do. So when you advertise in more traditional formats, you're usually telling what you're looking for. Someone for 6 months or a long-term rental.
Mm-hmm.
You don't have no real information that directly says that in these types of
But no one was
formats.
able to make an instant booking. They had to consult with us before we approved it.
I hear that, but that's not part of your advertisement. That's part of your consultation after the
Right,
fact.
but as you mentioned there, it didn't matter if they stayed for 2 months or 6 months. They still have the option of staying longer, and they can book that through the RBO.
Yes, and the option of staying shorter, which then
And stay longer, so I mean...
Not a debate. You're last,
I
and I'm
understand,
just trying to
but
answer, but I hear your points.
They just wouldn't be accepted if it wasn't for 180 days.
That's good faith, and we have to, but take that out of the picture by not going on those sites that are traditionally used for
I just didn't see
short-term
it
rental.
in the terminology of
It says no, because we even got this from your office downstairs,
Yeah.
and the lady down there
And
was
I-
very nice. Her name was Sharon, and she shared with us, you know what I mean?
We tried to find everything that would follow the rules, but the rules should be printed so you can follow them, and they weren't easily accessible. And when you get one rule that says one thing and another rule that says another.
Well, I'm presuming that there's...
Volusia County says 31 days. The other county says 181 days. I mean, so it's like the counties also need to be on the same page as well. I mean, I'm not saying how.
Well, that's not necessarily how it works in our state.
I understand.
But understand this.
So I guess we're just asking for some leniency.
Yes, most definitely.
Yeah, but just understand this as well. Once you've made a decision that's going to be long-term rental, then there's processes that you have to go through with our city anyway. And those processes...
We did get set up for that.
Yeah, and those processes can...
Go through it, though.
Right, but back when you were starting, those processes would have been able to answer some of these questions.
Actually, I didn't see anything that said you had to do a long-term rental and things. But I kept asking, I think it's because I was asking the wrong questions.
Yeah, because it's in our code.
But nobody was offering any additional information.
Yeah, but it's...
So it's hard when you're trying to get into a conversation to find out the rules, and they're not clearly posted.
You know,
Because
it's,
the other people had the same issue.
But
well,
yet,
well, it's in our code. So it's kind of
but
like
you can't
saying-
get access to the code.
No, it's online, sir. It's
doesn't-
available to everyone.
This one doesn't say it.
Wait,
It
wait.
says nothing about Airbnb or VBRO.
No, let me say what I said.
So-
It's in our code that long-term versus short-term, we have a rental ordinance. So there's things that you would need to do.
Right, so, and you can only
Right.
list for 180 days, so you've advertised for
180, they add on 1 day.
Right, so that's less.
One day. They never have a problem.
All right, we're back to debating, but I'm just informing as you have requested.
But
Thank
just
you.
to clarify, we can see from the reviews, they had a 59-night stay and they had a 43-night stay, which clearly violate the statute. So regardless of any of the things they were planning on doing going forward, we do know at least 2 times they rented short-term.
Well, that was after the fact, but when the people moved, when they asked us if they could stay longer, so that's when we had them actually do laces. So we used that platform to get a client. However, to keep our client, we signed leases that were above 180 days, 181 days.
Let me interject.
Let the honor
Let me interject here.
Okay.
My understanding, Daytona Beach regulates all form of rentals. There is short-term, 180 days or less, and that is limited to a couple little enclaves out on beachside, which are as provided for in the Land Development Code. There is a map, and it says you can do things in these different areas. Okay? If you rent out in those areas, you still have to have a rental license with the city. But that rental license only applies if you own one of those properties for short term. Okay?
We understand.
If you have a long term, 181 days or more, then you have to get another type of license, which is handled as a long term license. And that involves, I think both of them involve inspections of the premises to make sure everything is,
We've applied
is,
for
is
that.
habitable and all of that.
We've acquired a license. Or
So
we paid for it,
they-
everything.
I hate to say this, the easiest thing to do is to contact the city if you are going to lease and explain what it is you are trying to do. It sounds to me that your property is not in an area that is zoned for short-term leasing. So that's just off the table to begin with.
Sure. And I did contact the city, but I think I was asking the wrong questions and I got no additional information because the information they gave me didn't say I couldn't use VRO for a long-term tenant. And I did get a lease on day one, not after the fact, and he stayed for 203 days.
I would say this, if you wanted to do a ice cream truck, we probably would not specifically say, you cannot do ice cream trucks right here. But there will be restrictions and there will be laws, and so it's a business, and so you would have to find out, what can I legally do? What does it take? What's the rules here? And the same thing when you're doing short-term rentals. It's a business, it's a commercial venture, and so you have to find out the laws. And although the easiest thing to do is to just ask us and we tell you, the ultimate obligation is to determine what the law is, whether it's through a lawyer, your own readings, your research, your public library. It's
But
your
I contacted the
obligation
city,
to determine the law.
A direct quote from the city was, they can't mandate how you advertise. That's what she said to me.
I don't know.
And I'm like, okay, well, I'm taking 181 plus days. So now I'm not gonna do anything. I'm just asking for some leniency.
Mr. Yates, let me ask you this question.
Yes, sir.
You've looked at their website. There is a difference. If you have a long-term lease, usually it's for a period of a year or 2 years or 181 days.
Yes.
But it's not on a night-by-night basis.
No.
And typically, if I understand correctly, Airbnb and VRBO, usually the rate is based on a per-night basis. So if somebody decides to stay 181 days, they're paying for 181 individual day stays.
That's right.
That's a short-term rental.
No,
Yeah.
if you do 181 though, it's complying with your long-term, and that's what I had. And whether you break it down by day, month, or year, or 6 months, 9 months, 12 months, 18 months, it shouldn't matter. he had to stay 181, or he had to make a
Consecutive days.
commitment of
Consecutive.
181 days, and that's what he did. So how is that not in compliance? It shouldn't matter. Your thing says 181 days. Your thing doesn't say a long term has to be a 1 year, 2 years. It says 181 days. You guys are breaking it down by days. So what's wrong with VBRO breaking it down by a day?
But you need a long-term rental license.
I now know that, and I did apply for it, and I did pay for it.
You did.
And I don't have anyone living there.
So I guess it brings me back to my original question is, once we decide that we're going to go with long-term, which that's what we thought we were already doing, we are no longer allowed to use Airbnb or VRBO as an avenue to get our long-term rental. I mean, I'm just asking, and if not, what avenue are we allowed? Because in any of your guidelines or anything, it doesn't say you can do or can't do.
No prohibition. However, if it looks like a duck, we're going to call it a duck, and we're going to try.
So we're allowed to use this.
We're going
and
to
that?
try the best we can to persuade the magistrate, we the city, that there's a duck right here. Everything about it, it checks all the boxes for duck.
Okay, but moving
And so,
forward,
regardless of what you do, even if you put out just a nice little note in the newspaper that says, I want you to come here every night for $150, and understand, I want you to stay as long as you can, or up to over 161 days. If it looks like a duck, we're going to call it a duck, and it's going to be up to you to tell the magistrate otherwise. There's a way that you can do it that's smart, from my perspective.
Okay.
You can, get legal advice on it. So I think it's a bad choice to use this format,
We now know that.
but
But
I
everyone-
can't tell you.
Statute says
Hold on.
181 days.
But I can't tell you, and our code doesn't tell you that you can't use this format.
That's true.
Right, but everyone
your
is
code
guilty
says
by
100
association today. I
Yeah.
mean, 90%, it didn't matter if people stayed in the house for a year, 6 months, 6 days. They're all guilty
Your
for
code says
posting on that.
181 days, does it not? That's 181 days. That's the same thing as 30 days this is your daily rental. Your code says 181 days. You didn't break it down by months or years. You guys broke it down by a minimum of
We're
a
back
certain
to an
date.
argument, and I'm not in.
We're not
That's a
arguing.
duck. You said the duck looks like a duck. That looks like a duck for 181 days.
Yeah, we're there. I understand. I understand your viewpoint.
And I apologize for frustration, but I mean, you have to understand, because we were here listening to everybody today, and everyone was guilty by association. You guys never verified the fact that this person was here for 2 days, 2 weeks, 2 months, 2 years.
There's two choices. One is how long they stayed. The other one is the mere fact that you advertised.
But that didn't matter. That didn't even come up today as far as how many
We
people were
didn't
there.
know.
It did.
We did not know that was a violation, purely advertising.
Understand.
All we knew was that you had to have 181 days. So we thought we were in compliance. Had we known you couldn't use it, then we wouldn't.
I have a quick question.
Let's let Mr. Yates interject for a second. Mr. Yates is boots on the ground inspector, so.
So to clarify it a little more, I think that they're, claiming that they may have one lease, but first of all, we have 2 incidences. We have it in print. It's right here. How long did they stay according to the website? Well, there's your transaction period right there. Go down below it. You'll see another transaction period where it simply states how many days it was. So there was a transaction. Now, they may have done a separate thing, but here we have evidence of a 43-night transaction by them, verified by VRBO. They know they sent the money. I'm sure the terms and conditions say that any other term would be illegal and against their terms and conditions. So you're violating the terms and conditions of the website, and that's why you may find yourself here. So had you followed the terms and conditions of the website, you would not be here.
She
So-
actually, for the 2022, when she concluded her time with the Bureau, she then picked up a lease with us. I didn't
That's
know I was
fine,
gonna have
that's
to bring
separate.
that.
And we have
Otherwise,
proof.
I would have.
Yeah, no, it's
And then
fine.
you
It's a
see the
separate
next one was
transaction.
For early April of 2023. During his stay, he had a bout with kidney stones, and he had to go. And so he broke his lease, which we understand, and we picked up another tenant. We've had 3.
So let me.
All thinking that it was okay to be there for 181 days. We didn't
So
know.
let me ask you this. Had we had advertised on Facebook and we had never done this and the people stayed there for 2 weeks or 2 months, that's not a problem?
Absolutely.
But
That's a
they
short-term
can't
rental.
enforce
Well,
it.
but how are you going to enforce that? Because the only thing you're enforcing is the fact that
No. I've brought many people with Facebook ads. They're just not here today. It just depends which day you look at the cases. No, there's a variety of ways that we prove that you guys are doing this. You guys, for instance, have admitted, yes, we put that ad up.
Oh, yeah, we did.
Yes,
Because we thought we were in
and if you actually look, you'll see that the booking period for me was from December 1st to December 31st. nowhere near the 181 days that they claim.
Do you have a reservation? Because I never got the notice from
Yeah.
the
Oh, no,
You have
I don't
reservations
book.
saying that you
You
that we
have to,
rented
because you
it to
can put
you.
any numbers in. You can
Let's
click
get
on
back to the
numbers on the
magistrate, let
calendar.
him go ahead and make the decision.
Yeah.
The
Well,
magistrate makes.
so, but moving forward, we need to know how to move forward correctly, where we are allowed to advertise, because obviously everyone that's here today, and I'm just saying what I see today, has been guilty by association as far as pitting their home on an Airbnb or a VRBO. So moving forward, we're not going to sell our house, or we're not going to pick it up and move it to a different district or anything like that. So we want to know the safe, proper procedure, since we can't find out online.
I think we've already discussed that you want to get it 6 months. then
Let
get
me
it-
just tell
But you said
where I'm
181 days,
coming
and we
from.
honored that.
Let me tell you where I'm coming.
All right, I'm sorry, Your Honor.
There is a rental period, okay? The rental period is for the period, not for a day by day, a month by month, or what have you. If someone agrees, and in a previous matter today, I received a lease.
And we have that as well, sir.
For 1 year, okay? If they have a lease, that defines the rental period. If they're paying day per day and they may stay over, they're like being at a hotel. Okay, that is not, I do not consider that to be a rental period for purposes of this. It's a day-by-day rental period. And so that's the way I look at it, and that's how I see it. City may disagree with me, but, and that means that something like Airbnb or VRBO, where you're advertising a certain amount per night or per week or per month, those are all short-term rentals. If you advertised that there was 181 days for X number of dollars, and you required the person to enter into a lease for that amount, I see that as falling within the long term. But you would also have to get a long-term lease or a long-term permit from the city, and they may feel somewhat differently, I don't know.
Which we have.
But I mean, these short-term rental platforms are designed for short-term rentals. They're not designed for long-term. And if you're trying to get people to, and you advertise, because it's the holding out that matters, and that is the holding out. The minute that Airbnb puts up $100 a night or $75 a night, that's what the lease terms are. And if they stay 181 days, they still stayed 181 nights like they were in a hotel. And that's all short-term.
But we also have
Your
lease.
ordinance is 181 days.
So if they stayed 190 days, that's
Well, if they
okay.
stay, but if you advertise, if you were asking about advertising, these online will, I think most of the time ask for a per night rental or per something shorter than 181 days.
And you can't book a rental that long on either site.
You can
It's
do
not
180.
possible
VRBO.
to book a legal term on either website.
So it's technically it's not possible. So
It is on VBRO minus 1 day, but then when they call you, you can add on the day.
They can stay on that site and book 5 years.
Yeah, they can.
Yes, they
continue.
can.
Yes, they can.
They can stay on there and they can book 5 years.
In one
and
booking?
They pay the
They can
taxes,
book 180 in one booking, and then
There you
you
go.
can add on 1 day.
all consecutive.
And within the same
it's
reservation.
the 180 days that makes it a
But
short term.
your ordinance is by day too, so.
We
No,
have
it's a total number of days, not.
Sure.
we have a printout from VRBO, sir, that shows the consecutive days of the 203 days that the tenant stayed there. So there was no time where they moved out and came back in, because this was consecutive days. We also have a lease from that individual as well. And I apologize, you have been super cool throughout the night. We've heard and saw everything that was going on throughout the day, but it just seems to me,
And this says less than 6 months, not 181 days or 6 months and 1 day. So this is your guys' actual code. So this says 6 months, and we made him hold to 181-day minimum. And that's what he did rent for.
The city's recommendation is $100 fine to be imposed. They were holding it out. I'm sorry, I said $1,000 fine to be imposed. I'm sorry. I know you'll rather.
100 but sounded like it sounded a little bit more legit.
Yeah, we recommend $1,000 fine be imposed. There were, along with everything else, 2 reviews showing that that's consistent with the advertising itself, that it is short-term. The advertisement itself is holding out for a short-term stay, and that's the position of the
We
city.
would ask for some leniency like you gave to number 8. When he still had his ad running, we have ours completely removed. We have nobody in the premises. Nobody's renting. We have applied for the rental, even though we're not doing a rental. So I would just ask for some leniency. This is our first time here, and we will not be back.
Right, but in order not to be back, since we need to know move forward that obviously
Now we know.
you can't list your house on an Airbnb. So on a Craigslist, so as long as we have 181 days and we tell the person that it's going to be $500 for the 6 months, that's no problem.
Yes.
And if we have a guest coming in from Las Vegas and they stay there for 2 weeks, and your inspector or somebody comes by and says, "Oh, I see a strange car in the driveway," or whatever the case may be.
This isn't really the form for this.
Can you
It's,
No,
stop?
I'm just asking though. So moving forward, we don't have any problems. Then we're not back
Get
here.
with the inspector here, and he'll do his best to, being perspective is a very hard thing as far as what you may do in the future, but you do happen to have the knowledge of the code division, so you can make a contact with them and see, I'm about to do this, is that something that sounds like a problem to you?
Well,
Now,
having
that
my
doesn't,
friends
that
come
doesn't
from Las
stop you from
Vegas-
being cited, because you can get cited.
We
So
would just ask for some
get
leniency, Your Honor.
clarification when you operate in the future. There's no way we can give you a perspective answer on what's allowed. It's whatever you're doing. It depends on what you're doing.
But like you gave number 8 leniency, we'd ask for that same leniency. And he had a prior violation. We haven't.
We haven't really resolved a lot here.
Well, we'll talk to someone. We're just asking for leniency at this point because we're being,
We have some very good valid points.
I still see when you advertise on a short-term rental site and it's on a per diem basis or whatever, but something shorter than 181, that it's a short-term rental.
right.
And regardless of the number of days that accrue while that person is there, it's 180 different short-term rentals if it's 180 days, for instance.
But it wasn't. It was the same person.
And
That never checked out or checked
Never
in.
checked out.
well,
It was
if
And he
it's
did sign a
100,
lease.
if it's 181, then you are renting the unit without a long-term license.
Right, but we're not here for that violation. We're here for this one, and I'm just asking for some leniency on this, like you gave to the previous guy who already had a violation and paid $750 on that one, and you knocked it down to $500. So I'm just asking for the same leniency. This is my first-time offense, and I won't be back.
Well, most people won't be back, but I try to treat everybody to some extent. I mean, now, this is trying to push the language beyond where I think it can be pushed. And
Okay.
But we've demonstrated some very good facts. I mean, where are we allowed to advertise? Like I said, it is every 90% of everything that was happening today was a guilty by VRBO or Airbnb. It wasn't the fact that how many days people stayed there or how they got the client. It was-
I understand your argument, but I just don't feel that it is.
So we just asked for some leniency. Like number 8, it was his second offense, and you gave him a $500 fine. So I just asked that you did the same for us.
She means number 9,
Or number 9, sorry.
number 8.
Again, I don't see that there's a.
He had 2 violations, and you gave him a
But we're
reduction.
not-
And this is our first one. We're just asking for a reduction. There's precedent. You gave him a reduction. Why can't you give us a reduction? Because we tried to comply. We thought we were complying. We didn't realize you couldn't advertise on the site. And we thought because we told the tenant he would have to stay 181 days, and we got a lease, that we would that he would have to, then it would be legal, quote unquote. We didn't realize that you couldn't advertise on those platforms because we didn't see anything that said no advertising. We just saw that they had to stay 181 days. And as I understand, that would be a long-term. Not aware of that program. I am now, and I've gotten compliant with them, and I've paid for the thing with them, but I'm just asking for a reduction on this fine today, like you did for the other gentleman.
Every case stands, position of the city is that every case stands on its own. The facts differ.
How do they differ?
Specifically in this case, we have those.
I mean, you have a gentleman who is staying there as a short-term renter, and then you add a little extra time. Did you obtain a long-term rental license?
Yes, we tried to
Yes,
show
I did
you.
obtain a long-term rental license. I did. I paid the $114, and he's no longer there. He was not there when Mr. Yates came by, but I did have a lease for the time that he was there.
But it was an I assume it was an after-the-fact lease.
No, it was day one. He signed it when he moved in, because I thought
The license was after the fact.
The license was after, because I was unaware of it. But as soon as I became aware, just like when I became aware that I wasn't allowed to advertise, I took down the listing.
What was the cost of the?
$114.
I will knock $114 off, so it would be $886. But, all right.
We'll be able to contact you to find out what we can do and can't do.
I
gonna contact
specifically
someone
won't
else.
be telling you yes or no to websites, but if you have a specific question, I'm happy to answer.
So
But
therefore,
advertising it on this.
This isn't the form if you want to talk to me after.
Okay.
in case number 11, RTL 01-2409, Adam
McGahee? Yes, sir.
Okay. And Jennifer Spangler. I find the respondents to have been in noncompliance of Article 4, Section 4.1A, and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 275 Brookline Avenue, and to subsequently come into compliance on, do we have a compliance date, Mr. Yates?
11/17 stopped.
November 17th, 2023. And hereby order the respondents shall pay a fine in the amount of $886 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. That's it.
Okay.
I've actually left it in my car, unfortunately, but you have all my contact. It's on the violation.
What's on it? Okay. Thank you so much.
All right. Now, let's see, we're going to skip, as I said, case 10 for now, because there's no one here. We'll move to case 12. Is there someone here for case 12?
Zoom.
Yes, Zoom.
Okay.
Yes, ma'am.
Case number 12, RTL 01-2410, Tortola Sultan Express Trust, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1A, Article 5, Section 5.2.8.2 at 131 Tarragona Way.
Hi, can you hear us?
Yeah, I can. Can you hear me?
Yes, can you state your name, please?
Yes, my name is Magistrate Barnett.
Can you spell that?
MAJJDAH, and then Barnett is BARNETT.
And can you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And your relationship to Tortola Sultan Express Trust?
I am a representative of the trust, and I also live in the home.
When you say a representative of the trust, what do you mean?
I represent it.
As a trustee, as a beneficiary, as what? An attorney? Or, I don't know what you mean.
Co-trustee.
Okay.
Okay,
That works.
all right. And I didn't catch your last name yet, Ken?
Barnett?
Barnett?
Yes.
Okay. All right. Mr. Yates.
This case is before you for a zoning violation. The case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed November 15th, 2023. They were notified the same day. The property stopped actively advertising as November 17th, 2023, and the daily posted rate on the advertisement was $55. 14 reviews were displayed, and a check-in, check-out time of 4 p.m. and 10 a.m. were shown. This is the second case for this owner at this address, the first being RTL 092356 on 092623. These actions are irreparable and irreversible in nature, and as a result, due to the actions of the property owner, we're requesting a one-time fine of $15,000.
Mr. Yates, the 45, did you say 45?
40, the RTL case?
No, the number of
Violations.
of
14, I believe.
Reviews?
Reviews.
14.
14.
Sorry.
Are these time of the the previous case?
Yes, they're in August. Or no, I'm sorry. No, they're not. I'm sorry. No, in this case, they're not.
I mean, how many of them are subsequent?
They're not. They're before. The last case concluded on September, and those reviews are August.
Okay, so there are no subsequent reviews, but that doesn't mean that the property wasn't rented, would it? Does it? It just means nobody posted a review.
Yeah, it means nobody posted a review, but it was certainly advertised.
Okay.
Am I able to speak?
Okay.
Well,
Mr. Jackson.
Ma'am, I don't know, Ms. Barnett, I don't know if you were on when I presented to the magistrate my comments regarding finding that these violations are irreparable and irreversible in nature. If you were, one among the things we can do is I can go over that again and present that to the magistrate. You can waive me going over that again if you so elect, and we will proceed with having the magistrate just recognize it from a prior reading back in case number 3.
We could go ahead and go over that.
Okay, sure, certainly. As I've said before, Mr. Magistrate, and for the benefit of Ms. Barnett and anyone else who's listening, the city's position is that these violations are irreparable and irreversible in nature, which is a provision that's provided in Chapter 162.09, subsection 1D of Florida statute. And that's because the nature of the violations are as follows. It's a beneficial gain to property owners who are doing conduct or who are advertising conduct that is prohibited by our code. They affect rental property, renting property or holding out property as vacation rentals, and that cannot be reversed or repaired. Property is advertised worldwide, marketing a destination that draws people from all over the world for principal special events such as Daytona 500 races, Bike Week, Biketoberfest, and throughout the spring and summer to the world's most famous beach. The properties may also be marketed as a draw to nearby destinations such as Disney World and the Space Coast. Once the properties are advertised, they're never truly unadvertised. The reality of the World Wide Web is that you cannot push such advertisements back into the tube. Information posted today can be printed, saved, forwarded, and even copied and pasted on other sites. And it limits the city to the only solution for the advertisement is to require that all postings be removed. SmartInsights.com, which is a marketing website, provides that as of October 2023, 95 billion people around the world use social media and and they can be reached by these advertisements. The effects of these advertisements and this conduct is that information has a long-range effect in luring patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety, and welfare due to unregulated or self-regulated vacation accommodations that patrons enter into at their own risk. One single day of advertising can potentially book a property for the whole year. These promised stays are potentially to the detriment of the patron, and definitely they're to the detriment of the licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulation, proper inspections, proper licensing, proper insurance, and proper taxations that are required by law. The transit nature of the rentals limit the means of the enforcement typically to identifying advertisements. By the time code enforcement arises to the property, the transit patrons typically are gone from the property, or if they are there, they're claiming misleading relationships that are often contradicted by their posted comments or reviews. The monetary effect of these unlawful rentals is tax avoidance, inadequate insurance coverage, unfair business competition against the accommodations businesses, and unfair competition against lawful vacation rentals. The community effect is that transient business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods, and they diverge from the traditional and reliable residential norms. There is a demand, and has been a demand, from our business community to our city commission, which has led to a request for a strong deterrent to those that are raking in profits and avoiding state and local taxes, and avoiding zoning requirements and regulatory controls. We have all seen rentals going for as much as several $1,000s a week and realize substantial fines are the only deterrent tool available. By the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests a finding that these violations are irreparable or irreversible in nature as provided by the statute. And as I've brought up before, when we start looking at the fines themselves, we're asked to look at the gravity of the violation, and because of what's been stated, the gravity of violation is substantial, and such fines, we believe, warrant a $15,000 fine, especially when they're repeat violations. We look at, and it's appropriate for us to discuss the efforts of the respondent to comply and what efforts were made. And so with those things being considered, we ask the magistrate to make such a finding upon the conclusion of this proceeding.
Am I able to speak now?
It's your turn. Yes, you may speak.
I just wanted to say that I have no knowledge of an Airbnb listing. I gained control of the property in November. I have no control over any Airbnb listing. I have no knowledge of an Airbnb listing. Me and my family, we live here. I have a daughter. I don't want short-term rentals in my home because I just don't think it's safe for my daughter. I believe Mr. Kevin Yates, he pulled up to my house on November 14th, and he spoke to my brother-in-law. I hear that this is a second violation. I have no knowledge of a first violation. What else was I gonna say? And yeah, that's my testimony. Also, this is my first time seeing what evidence you have brought against me. I've never even seen this Airbnb listing. Taylor to, what is the name of the owner of the Airbnb account? Taylor to you. I have no knowledge of this company or who this is. This must have been before I even gained control of the property, or I really have no knowledge of.
Okay, ma'am, are you saying you bought the property in November?
No, I'm not saying I moved in the property. I don't have control over any Airbnb listings that are from the property or listed on the property. I have no knowledge. Me and my family.
Ma'am, if I may interject, this is really an action against the property. It's not against you. And this property, someone with authority with respect to this property is apparently advertising it based on the evidence that's shown. You may not know of it, but that is sort of irrelevant. The property is being advertised as an Airbnb. Am I correct in that, Mr. Yates?
Yes, sir.
Thank you.
But if I who live in the home has no control over an Airbnb listing, how am I supposed to regulate or be in compliance?
We're going to make certain acknowledgments, Mr. Riggio, just for the sake of fairness. We do acknowledge and we see that we do have a quitclaim deed that went from Mr. Raheel Taylor, I think that's Raheel, I can't see.
Yes.
From Raheel Taylor to the Trotola Sultan Express Trust.
Yes.
On October 22nd of 2023, which would have been approximately, based on our determination, would have been about 2.5 weeks, 3 weeks, I guess, from the time that we identified it. So we will acknowledge that it was within 3 weeks of the posting that we found.
Are you saying that somebody else owned the property?
When it came through the first time,
Okay.
this person, Mr. Taylor, did own the property, and he conveyed it in October 27th to this trust. I guess it's the possibility of them having had a posting up there prior to that conveyance. I don't know, and I can't speak that, and I'm not going to try to. But what I will do is acknowledge where we are in that regard and not leave that portion misled or misunderstood.
Okay, so the previous set of violations were against Mr. Taylor?
It would have been against the property, but it was
But
while
against the
Mr.
property.
Taylor was the at least owner of the
He
property.
was the owner of the property.
According to what we have before us from the quitclaim deed.
Okay, so we can sort of take the repeat violation off of here? I mean, if he...
Yeah, that would be correct. It would be,
Okay.
it would be taken off.
All right.
So it would not be a repeat
He conveyed
violation.
it on 10/22/23. Okay. The violations arise, or the postings on it are on 11/15, and somebody took it off on 11/17. Mr. Yates, you probably handled that.
Yes.
Who did you contact?
I did not get a contact. It was just taken down.
Oh, it was just taken down?
Yeah, it was taken down. No one contacted me. It was just taken down.
And you didn't contact them, or you sent out a notification?
Yeah, and I posted the property.
Okay. So somebody got the notification on the 15th and immediately took it down.
Yes.
Do you have any idea of, on the posting, who they said they were? I mean, I assume on Airbnb, I don't know what's on that website, that you send your money somewhere, or you...
Well, you just pick whatever name you want to display. It has nothing to do with your real name. You do not have to use your real name. You can
Okay.
just make it up out of the air.
But is there like a phone number? Or?
No. You can only let you speak through the app, so they don't lose any revenue.
Okay. So the rentor can't go around the web page and get to the owner
Correct.
and cut a deal.
Right. They attempt to limit that the most they can.
Okay. So
Now, is this listing still active? I'd like to reach out to Airbnb because I don't want to be held responsible for something I don't even have control over.
Ma'am, as I understand it, somebody took after the property was noticed, within like 2 days, am I correct on this, took down?
Yes.
Somebody
It
did.
was on the 15th, and it comes down the 17th.
And that would have been somebody probably who saw the notice on the property. Well, I'm trying to narrow down who's doing what. And I understand, I'm trying to figure out the questions that you posed as to what's going on here. I would assume somebody in Daytona Beach would have gone by, seen the notice, and said, okay, the property cited, I'll take it down.
Ma'am, when did you occupy the property?
November 1st.
November 3rd?
First.
November 1st. Are you the only one who occupied what, you mentioned that you had a family. Is there any?
Yeah, I have a family, and
Are there any other adults occupying the property?
yes, my brother-in-law and my husband. But they don't have Airbnb. They don't even use Airbnb. Or I don't know, that's all I could say.
Does Mr. Taylor live in this area?
I don't know. No, I don't even know Mr. Taylor.
Okay. I'm just trying to figure out who took it down. It's sort of a mystery person. If it's not you or your family, and Mr. Taylor's not here, somebody saw this notice and then did the right thing.
I can't attest to that. I only could attest to my knowledge. I know for a fact nobody in my family.
I don't want you to speculate. You just can only testify as to what you actually know. And so
And the only evidence is screenshots off of a website that.
Well, as it appears, you all took possession of the property through a deed from a Mr. Taylor on or about the 22nd of October. You were on the property as of, you said, November 1st or thereabouts?
Yes.
And somebody, was this a new website, or was this simply bringing back the old one, Mr. Yates?
It is a different ad. It is for a different room in the same house.
Okay. And somehow this mysteriously appears. A notification is, I take it you posted it on the property.
Yes.
Somebody saw the notification and took down the Airbnb posting.
But that's speculation as well.
No, no, that's not speculation. We know somebody took it down. And we know somebody put it up, and we know somebody took it down. We just don't know at this point who.
After reviewing the old case,
Yes.
The naming convention, the Casa de Taylor, is strikingly similar to what the owner before them used. It also had Taylor in there, I believe. And so we believe that there's a chance that it could be the former owner who had left it open and then possibly closed it. So we would like to dismiss the case.
Okay. You heard that. It may be that your previous owner had some remorse seeing that his website had reemerged and he has a new owner who's probably going to come after him.
Okay.
And took it down on his own. I don't know. No, it's speculation. But this, if I'm correct, the city would like this case to be dismissed?
Yes.
We're kind of giving it a benefit of the doubt, looking at the paperwork as it is.
Okay. So,
Thank you. I appreciate it.
yes, so therefore, I'm going to dismiss this case.
Thank you.
It appears that you, based on your testimony and what we've been able to find, had no involvement in this. So in case number 12, RTL 01-2410, Totoral Sultan Express Trust for property at 131 Tarragona Way, I hereby order that this case be dismissed. That's it.
All right. Thank you. I appreciate it. I appreciate it. Can I go? Can I exit the call?
You're done.
All right. Thank you.
Have a good day. Okay. Case number 13, RTL 01-2411, Karen C. Gerner, cited for failure to correct violations of Land Development Code Article 4, Section 4.1A, Article 5, Section 5.2.8.2 at 830 South Grandview Avenue.
State your name, please. Christine? Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? So are you the owner of the property or representing? Okay.
Mr. Yates, are you ready?
Yes, sir. The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed November 29, 2023, and they were notified the same day. The property stopped actively advertising as of December 8, 2023. The daily posted rate was $45 and displayed one review. The rules showed as quiet hours from 10 p.m. to 8 a.m. These actions are irreparable.
Slow down just a little bit, please. I mean, okay.
The quiet hours are from 10 p.m. to 8 a.m. This case is irreparable and irreversible in nature, and due to the actions of the property owner, we're requesting a one-time fine of $1,000.
And Ms. Gerner, are you Karen C. Gerner? Okay, and the C is for Ms. Christine. I thought you said Christine somewhere in there. Okay, okay, I got you. Okay, so Ms. Gerner, I've previously presented, in fact, I just presented a couple of cases ago, the city's position as relates to a determination that, a request for the magistrate to make a determination that these violations are irreparable and irreversible in nature. I'm Anthony Jackson. I'm willing to if you desire. Okay, and I'm the attorney for the city, and so if you're saying you're okay for us to okay with waiving that, then I would ask the magistrate to just make noted for the record that it's part of this case as well.
Okay. In this case, the respondent has waived hearing Mr. Jackson's statements regarding irreparable and irreversible and agreed to incorporate his previous comments from case number 3, heard earlier today, into this matter. Okay.
I have nothing further, so.
Nothing further?
Okay, Ms. Gerner, it's your turn.
I apologize. I didn't know. I accept your
Okay. Then, in this case, in case number 13, RTL 01-2411, I find the respondent, Karen C. Gerner, to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D, Florida statutes, for the property at 830 South Grandview Avenue, and to subsequently come into compliance on November 29, 2023, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes.
Mr. Riggio, I believe the compliance date was 12/8,
Oh, I'm sorry.
not the first notification.
It came into compliance. Please change that on the order from came into compliance on December 8, 2023.
Thank you.
Case number 14. Are there any other respondents? Looks like you're the last one. Case number 14, RTL 01-2413, Angelica Marie Ham, cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 212 Goodall Avenue.
Could you state your name, please? Raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
Okay. Mr. Yates.
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed November 30th, 2023, and they were notified the same day. The property stopped actively advertising as of December 1st, 2023. The daily posted rate was $168. The advertisement displayed 19 reviews. The check-in, check-out time were shown as 2 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, we're requesting a one-time fine of $1,000.
Okay. Mr. Jackson.
Okay, you pretty much said it all, Miss Ham. My name is Anthony Jackson. I'm attorney for the city, and I think you're indicating that you're willing to waive repeating the city's statement. Yes. Okay. Thank you.
All right. Ms. Ham, this is your opportunity to say anything you wish in your defense. Okay. Well, doing the right thing, getting it resolved. All right. There will be, the city has asked for $1,000.
Correct.
Okay. All right. In case number 14, RTL 01-2413, I find the respondent, Angelica Marie Ham, who have been in noncompliance with Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and as such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 212 Goodall Avenue, and to have subsequently come into compliance on November 30th, 2023, December 1st, 2023, and hereby order the respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes.
Thank you.
We did have one more, number 19.
We have one more.
Case 19.
Are you Samantha May Minton?
We saved the best for last.
Okay. This is case number 19, RTL 01-2419. Samantha May Minton is cited for failure to correct violations of Land Development Code, Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 120 Maplewood Drive.
Ms. Minton, raise your right hand. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you.
Okay. Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned SFR5. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed October 26, 2023, and they were notified the same day. The property was still stopped actively advertising as of January 17th, 2024. The daily posted rate was $43. The advertisement displayed 16 reviews. The check-in, check-out time were shown as 3 p.m. and 11 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $5,000.
Okay. Mr. Jackson?
Yes, Ms. Minton, just for the record, Anthony Jackson, I've presented this, information as far as the city's comments regarding short-term rental irreparable, reversible, being found to be irreparable and irreversible in nature. That request has been made of Mr. Magistrate before. You're indicating that you desire to waive me presenting that once again. And I would ask for the magistrate to just adopt a prior statement into this proceeding.
Yes, sir.
Okay. If you're in agreement with that, let the record reflect that the respondent waives Mr. Jackson presenting again his comments regarding irreversible and irreparable, and that we will, and to incorporate the comments that he made earlier in the day in case number 3, and those comments that were made there will be incorporated into this proceeding. Okay.
Okay. I start?
Yeah, it's your turn.
All right. I was not informed that it was moving up to 5,000. I was under the understanding that it was still set at 1,000. I would like to preferably get it reduced back down to 1,000. I have records that show that I canceled and locked every single day after October 26th. I was under the impression that doing that would remove my listing. I was not informed that my listing was still active until last week when I got an email from you, sir.
Yeah.
Mr. Yates. It was not kept up with malicious intent. So,
You might want to give those to Mr. Yates.
if that works. And while I don't have them on me, I am fully willing to pull up like bank statements or what have you. While I can technically afford 5,000, it will wipe out my savings. So any reduction would be helpful at this point.
Mr. Yates, is there any evidence that this property has been rented out after the 10/26 notification?
No. And I will say that when I did contact her, similar to some other people who were saying that their calendars were off, her calendar was off. So you would have to contact them directly if a booking was to occur.
Okay.
Just to clarify, I myself went into Airbnb to check. My house does not show up unless you specifically look up my address. So I was under the impression that it was not showing, and I did not type in my own address to see it pop up.
Okay. Mr. Yates, do you have anything to add?
No. I mean, she seemed genuine. When I saw it was still up, I had known that she had said she was taking it down. And so I contacted her, and at that point, when we did speak, then she took it down on the 17th when we spoke. I should say when we spoke again. We had already spoken previously.
Okay. Ms. Minton, I was not involved in the conversation between you and Mr. Yates regarding what needed to be done.
Mm-hmm.
Do you recall what he said needed to be done?
That it needed, Lord, that was a long time ago. Yeah, no, this is back in October.
I mean, what led you to cancel and block as opposed to just taking it down?
Oh, I did that before I even called him. It was my immediate action the day of. I was up until almost midnight between going through the postings and canceling each individual future posting, and then online with Airbnb customer service to make sure that everybody got taken care of after that point. It wasn't until, I want to say, Wednesday?
Wednesday is
Wednesday.
the 17th, I believe, is the day I recontacted you and was like, hey, this is still up and this is going to affect your fine amount.
Well, no, I'm thinking it was like Wednesday in October or November, that first time where I called you and you called me back while I was still at work and I was having a panic attack.
Somewhere in late October, yes.
Yeah, it had to have been like the week after, because I sent him a voice message that he responded to, like the first day he came back in that week, where we went over making sure that the listing was taken down and all of the details of that. The miscommunication was what exactly qualified as taking the listing down, because I thought I had, between blocking everything and making sure that nobody else could apply for anything.
Okay, I'm just trying to understand. It seemed like you did a lot after his call, but if I understand what Mr. Yates is saying, you didn't do basically taking the site down as opposed to taking and canceling and blocking all the people, which may very well accomplish the same thing, although we have had situations where people do that and then it just goes back up again.
Yes, no, it is currently very much taken down. I deleted the whole thing. I don't even have access to the renter support tools anymore. And that was as of last week when he contacted me via email. It's just a misunderstanding of, what's the word for it? That's probably the best summary I can. It was a misunderstanding of what qualified as taking it down. At the time, I do not believe he walked me through like how to make it inactive back in October, November.
And that's not something I do, by the way.
Yeah,
Only if you requested, like, sir, could you take extra time out of your day and show me how to navigate my...
Yeah, which is perfectly understandable. Anyone who does this, it's rather on them to like cross their T's, dot their I's. It wasn't until I did a whole Google search to figure out how to deactivate the account, because it's not actually stated anywhere that's easily accessible within the Airbnb website. You have to go outside of it, look it up, and then follow the directions from there. Like I said, I was under the impression my actions up to that point had already deactivated the account.
The only thing I'll say is, as she did say when I did talk to her the second time, and re-clarify that this is not deleted, it was taken down that day.
Okay.
Need a volunteer for creating YouTubes on how to take it down, I guess, but I have nothing to offer other than what's been presented.
I guess the issue comes down to 5,000 versus 1,000.
Yeah, I was originally going to ask for a reduction of the 1,000. The 5,000 was rather a surprise.
And
I will say that when I consulted with Mr. Yates about a week ago or so, it was at 15,000 because I guess what's not resolved.
Right.
But it's been since resolved. So there's a range depending on what happens and when it happens, and that has just been the reality of how we've addressed these. I would have no opposition to whatever the position that you take in this regard, Mr.
well, I guess the question comes down to the final result that occurred. If the final result is to render that site so, or that there are no more bookings, and Mr. Yates would like to see it such that the only way you can do that is to have to set up a new site, which I suspect makes it easier for you to find it if that should occur.
Well, no, it's a little bit easier because I can do a reverse image search on the other one because I already have the photos, and then it'll just search for me. But regardless, it's tougher on them because they don't have all their reviews. And the biggest thing for an Airbnb or a VRBO is those first 5 reviews. Until you get those first 5 reviews, there's a whole subsection of people that would never book your place. So losing your reviews is a really big deal. So that's why we insist that you close it so you can't. We've had people who just turn it on, Friday, 11 p.m. to Sunday, 11 p.m. And I'll never see it then.
And Mr. Riggio, you may have noticed that I've slightly changed my my comments regarding irreparable and irreversible, and that's took into account, recognized that while I say that it's virtually never truly unadvertised, it leads me to have to acknowledge that our only shot at someone not pulling it up or having some of these things that people have suggested, the shocking surprise that it's there again, is by telling them, take it down. And so that's kind of what I now say is that our only true solution for the advertisements is to require that all the postings be removed. Without complete removal, they're always possible to be utilized again, always possible to be brought up, always possible to be re-referenced from the last time they were there. And so that's kind of the reality of how sophisticated we are.
Yeah. No, I know that very well for the fact that I can still access all the photos from when I originally bought my house on Zillow. So, yeah, things never disappear. I only want you to take into consideration that I acted in good faith and just did not quite hit the mark.
Okay. I'm taking everything into consideration, and I understand Mr. Jackson's comments about the fact that the posting still sits out there, but it's not completely gone.
Yes, sir.
I also understand that you attempted to comply, and there doesn't appear to be any evidence that the property was rented out as a result of the stuff that you hadn't taken down.
Mhm.
You had canceled everything. And so I'm going to try to get in between figure, and I'm thinking of a fine of $2,000.
That is sufficient, sir. Thank you.
All right. So therefore, in case number 19, RTL 012419, I find the respondent, Samantha May Minton, to have been in noncompliance of Article 4, Section 4.1A, and Article 5, Section 5.2.A.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner in a damaged surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 120 Maplewood Drive, and to subsequently come into compliance on January 17th, 2024. And hereby order the respondent shall pay a fine in the amount of $2,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Thank you.
Thank you.
I know you've already answered the others before that you'll be sending out the notice for the fine and how to pay it. Will that be coming through mail or and
Yeah, it'll come in through mail unless you want to leave your email address.
I'm good with mail. Do I have to come back in to pay it at the offices downstairs or beautiful? Thank you.
You're welcome.
Y'all have a good day.
Thank you.
Yeah,
Fair enough.
we agree.
Okay. I have 3 cases that there remain for action to be taken on 10, 17, and 18. And
That's correct.
there are no respondents present, so let's go through those. We'll start with case number 10. RTL 012408 TR Property Group LLC, cited for failure to correct violations of Land Development Code Article 4, Section 4.1A, Article 5, Section 5.2.A.2 at 126 West Gardner Court. Is there anyone in the room here on behalf of TR Property Group LLC? There is no one here. So, Mr. Yates?
The case before you is a zoning violation. This case was field generated. The property is zoned RDD6. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed November 9th, 2023, and they were notified the same day. The property is still actively advertising as of today. The daily posted rate on the advertisement was $82. The advertisement rules show a check-in, check-out time of 3 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, requesting a one-time fine of $15,000.
Okay, Mr. Jackson.
Mr. Riggio, I previously presented the city's comments regarding short-term rental and as relates to a request that you make a finding that these violations are irreparable, or that the violation itself of the ordinance is irreparable and irreversible in nature as provided in 16209 1D. I know you've asked me in the past, especially in these circumstances where we have someone not appearing and we're asking for maximum fine, to go ahead and make this presentation again. And if that's something you desire, go ahead and make it again.
I don't think we can have the respondent agree
Certainly. to
waive that, and I think that's...
And that's fine, well understood. And so I would say that there's the benefit to gain to the property owner in is that they're doing advertising, that they're doing a conduct or advertising a conduct that is prohibited by our code. It affects renting property or holding out property as vacation rental, and it cannot be reversed or repaired. The property is advertised worldwide, and it markets a destination that draws people from all over the world for our principal special events such as Daytona 500 races, the Bike Week, Biketoberfest, and as I said before, throughout our spring and summer months, primarily for our world's most famous beach. The properties may also be marketed as a draw to nearby destinations such as Disney and Space Coast. Once the properties are advertised, it can't be unadvertised. The reality of the web is that you cannot push such advertisements back into the tube, kind of like toothpaste. Information posted today can be printed and saved, forwarded, and even copied and posted on other sites. And it limits the city to the only solution for the advertisement is to require that all postings be removed. And said before, smartinsights.com marketing website provides that as of October 2023, 4.95 billion people around the world use social media and can be reached by the advertisements. The information has long-range effect in luring patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety, and welfare due to regulated, unregulated, or self-regulated vacation accommodations that the patrons enter into at their own risk. A single day of advertising, potentially book a property for a whole year. Their promised stays are potentially to the detriment of the patron, and they're definitely to the detriment of licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulations, proper inspection, proper licensing, proper insurance, and proper taxation required by law. The transit nature of the rental limit the means of the enforcement, typically to identifying the advertisements. By the time code enforcement arrives to properties,
The transient patrons typically are gone from the property, or they're claiming misleading relationships that are often contradicted by the advertised reviews. The monetary effect of these unlawful rentals is tax avoidance and inadequate insurance coverage and unfair business competition against the lawful accommodations businesses and lawful vacation rentals. The community effect is that transient business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in residential neighborhoods, and they divert from the traditional and reliable residential norms. The demand from our business community in this city and to our city commission has been led to a request by the commission for a strong deterrent to those that are raking in profits, avoiding state and local taxes, avoiding zoning requirements and regulatory controls. We have all seen rentals going for amounts as much as several $1,000s a week. And we realize substantial fines are the only deterrent tool available. By the time we arrive and say stop, the beneficial gains are already realized. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests a finding that these violations are irreparable or irreversible in nature. And under the circumstances, we ask that this, looking at the gravity of the violation and in consideration of what has been presented, both in these comments as well as through the report of the staff, we are asking for $15,000 fine to be imposed. And based on the efforts of the respondent of having this violation continuing.
Okay, is that correct?
Okay. You from Mike? Is that correct?
All right. Ms. Barnes?
Yes.
Has the respondent received the notice of hearing? I noticed the packet.
I believe this one was posted.
Okay. The notice itself for hearing?
Yes.
In the materials, there's also
And
mailing.
there's a tenant in the other unit who I was able to speak to, and they didn't want to give me contact information, but they did say they were letting the landlord know. And that was true for the first posting and the second.
But there was a mailing, and I guess it's the question of the magistrate, and I guess the question would be whether there was a return. Because she's down.
Service on the
Or any tracking information that we are able to provide.
delivered.
It was delivered.
It was delivered to the owner and the registered agent. It was delivered to the owner on January the 6th, 2024 at 1:09 p.m. It was delivered to the, that's the registered agent. It was delivered to the owner on January 8th, 2024 in Sacramento, California.
Okay. So both the registered agent and the owner have received notice of this hearing?
Yes, sir.
Okay. And the city is requesting a fine in the amount of $15,000.
Yes, sir.
And this, is this Airbnb or VRBO webs?
This one is, I believe this is Airbnb. Can you look at the first slide? VRBO, sorry.
VRBO, and that website still active?
Yes. I haven't been able to check it in 45 minutes because my iPad died, but 45 minutes ago. I checked
45
it.
minutes ago, that's active enough. It should have been down by today's hearing. So therefore, do you have anything further, Mr. Jackson, that you wish to put in the record?
No, nothing further. We realize that these violations are per occurrence, and we know that we have a situation where every day is a violation by the definition of the statute. We probably would give a reasonable time for him to get this notification that he has a fine. And from that point forward, we very well may be coming to site again if it's not resolved. Some people look at it as a cost of doing business.
Okay, well, the owner and the registered agent have had the notice of this hearing now for almost 2 weeks. And they've taken no steps to resolve the violation or to even,
At least none that the city's aware of.
Yeah, not that I'm aware of. They haven't.
Okay. So the fine certainly seems warranted under the circumstances. So therefore, in case number 10, RTL 01-2408, find the respondent TR Property Group LLC to have been in noncompliance of Article 4, Section 4.1A and Article 5, Section 5.2.8.2 of the Land Development Code, which prohibits short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damages to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D Florida statutes for the property at 126 West Gardner Court and to subsequently and as of this date, January 23, 2024, has yet to come into compliance, and hereby order that respondent shall pay a fine in the amount of $15,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes.
Thank you.
Okay, that's done. Now we move to case 17.
Yes, sir.
Case 17, RTL 01-2416. PGSR Holdings LLC is cited for failure to correct violations of Land Development Code Article 4, Section .4.1.A, Article 5, Section 5.2.8.2 at 130 Springwood Drive. Is there anyone here on behalf of PGSR Holdings LLC? There is no one present on behalf of that entity. Mr. Yates.
The case before you is a zoning violation. This case was field generated. The property is zoned SFR 5. Other accommodations known as short-term rentals are not permitted in this zoning district. The violation was first observed December 28, 2023, and they were notified the same day. The property stopped actively advertising as of January 2nd, 2024. The daily posted rate was $168. The advertisement displayed 2 reviews. The check-in, check-out time were shown as 4 p.m. and 10 a.m. These actions are irreparable and irreversible in nature, and as a result of the property owner's actions, we're requesting a one-time fine of $1,000.
Of 1,000?
Yes.
They corrected it.
Yes, January 2nd.
All right. Mr. Jackson.
And again, Mr. Riggio, just 4 comments related to the irreparable, irreversible nature of these violations. Would just like to point out that there's a beneficial gain to the property owner for doing conduct or advertising conduct that is prohibited by our code. And these effects are on the rental properties or holding out property as vacation rentals cannot be reversed or repaired. The information's long-range effects and luring patrons under contract to participate in unlawful stays in our city. It advertises in a worldwide market to a destination that draws people from all over the world for our special events such as the Daytona 500 races, Bike Week, Oktoberfest, and our spring breaks throughout the summer and the summer beach activities. We recognize that in one single day, a property can be booked for as much as a whole year. And these promised stays are detrimental to patrons and it's detrimental to licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulation, proper inspection, proper licensing, proper
insurance, and proper taxation that's required by law. The transient nature of these rentals limit the means of enforcement typically to identifying the ads. By the time the code enforcement arrives to a property where we believe there's a transient patron, they're typically gone from the property, or they claim some misleading relationships that are often contradicted by the advertised reviews. There's a monetary effect that goes along with these unlawful rentals. There's tax avoidance, inadequate insurance coverage, unfair business competition against lawful hotels and motels and lawful vacation rentals. The community effect is that the transient business uses within unauthorized residential neighborhoods, they affect density, parking, home, and safety. They affect the peaceful enjoyment expected in residential neighborhoods, and they diverge from traditional and reliable residential norms. In response to the demand from the business community, our commission has asked us to seek a strong deterrent for those who are raking in those profits, avoiding the taxes and avoiding zoning requirements and regulatory controls. And we've seen properties that go for as much as $1,000 a week. And by the time we arrive and tell them stop the conduct, the benefit gains have already been realized. And state law has allowed us, and by the way, the state laws we've adopted it, permits the city to define vacation rentals to include advertising for transient guests. Therefore, the city requests a finding that these violations are irreparable or reversible in nature, and that the fine as requested be imposed. And in this case, I believe, based on a quick response to the respondent or the violator, the staff is asking for a fine of $1,000.
Okay. Ms. Barnes?
Yes, sir.
I see that there was delivery of was that the notice of this hearing?
Yes, sir.
And I see that it was delivered to an individual.
Yes, sir.
And there's just one. Do you know who that individual was?
I believe it to be Michael Cantor.
Okay, that's the registered agent?
That is the registered agent and the, I thought he was also, it is the registered agent.
Okay.
Oh, there you go, registered agent, yeah. And it is also the address of the manager of the corporation.
Okay.
The registered agent and the owner are at the same address.
Okay. So therefore, in case number 14, RTL 01-2413, am I in?
Number 17?
17, yes.
17.
I thought I was. Case number 17, RTL 01-2416. I find the respondent, PGSR Holdings, LLC, to have been in noncompliance with Article 4, Section 4.1.a, and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals. Such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damages to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.09D, Florida statutes, for the property at 130 Springwood Drive, and it was subsequently come into compliance on, Mr. Yates, do you have a compliance date?
January the 2nd, I believe.
January 2nd, that's correct. January 2nd, 2024. And hereby order, respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again. And for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. Okay. Case number 18, RTL 01-2418, Erica Liska, is cited for failure to correct violations of Land Development Code Article 4, Section 4.1.a, Article 5, Section 5.2.a.2 at 314 Williams Avenue. Is there anyone here on behalf of Erica Liska? There is no one here on behalf of Erica Liska. The respondent is not present. Mr. Yates.
This case is before you for a zoning violation. The case was field generated. The property is zoned SFR 5. Excuse me. Other accommodations known as short-term rentals are not permitted in the zoning district. The violation was first observed September 15, 2023, and they were notified the same day. The property stopped actively advertising as of September 19, 2023, and the daily posted rate was $120. The advertisement displayed 15 reviews with a check-in, check-out time of 4 p.m. to 2 a.m. and 10 a.m. These actions are irreparable and irreversible in nature, and due to the actions of the property owner, the city is requesting a one-time fine of $1,000.
Mr. Jackson.
Ms. Riggio, the city would like to make its comments for the record as it relates to our request that you make a finding of that these violations are irreparable and irreversible in nature as provided in Chapter 162, Section 162.09, subsection 1D. The nature of these violations are that there's a beneficial gain to the property owner for doing conduct or advertising in our city, conduct that is prohibited by the city's code. The effects of rental property or holding out property as a vacation rental cannot be reversed or repaired. The property is advertised on the worldwide market. Destination draws people from all over the world to our special events such as the 500 races, the Bike Week, Biketoberfest, and our world's most famous beach. We also market and draw people to nearby destinations such as Disney World and Space Coast. And once it's advertised, it can't be unadvertised. Information posted today can be printed, saved, forwarded, even copied, pasted to other sites. And so the city is limited to the solution of demanding that these advertisements be completely removed, all postings be removed from the sites. SmartInsight.com marketing website provides that as of October 2023, 4.95 billion people around the world use social media and can be reached by the advertisements. The information has long-range effects in luring patrons under contract to participate in unlawful stays in our city. The patrons risk poor health, poor safety, welfare due to unregulated or self-regulated vacation accommodations that they enter into at their own risk. One single day of advertising can potentially book a property for the whole year. And these promised days are a potential detriment to the patrons and definitely a detriment to the licensed hotels, motels, and lawful vacation rentals that have gone through proper zoning regulations, proper inspection, proper licensing, proper insurance, and proper taxation that's required by law. The transit nature of these rentals limit the means of the enforcement typically to identifying advertisements. By the time the code enforcement arrives to properties where it's been alleged that there's transient patrons, they typically are gone from the property, or they make claims that they have some special relationship with the respondent that are often contradicted by the advertised reviews. There's a monetary effect that these unlawful rentals experience, and it's tax avoidance, inadequate insurance coverage, unfair business competition that's against the lawful accommodation business and lawful vacation rentals. The community effect is that the transit business use within unauthorized residential neighborhoods affect density, parking, noise, and safety. They affect the peaceful enjoyment expected in normal residential neighborhoods and diverge from traditional, reliable residential norms. The business community has made it a request of our city commission that we create strong deterrent to those who are raking in profits, avoiding state and local taxes, avoiding zoning requirements and regulatory controls. And because we've seen rentals that go for as much as thousands of dollars a week and realize substantial fines are the only deterrent to that we have available. By the time we arrive and say stop, the beneficial gains are already realized. So we ask for substantial fines. State law adopted by the city defines vacation rentals to include advertising for transient guests. Therefore, the city requests that the findings that you make today regarding this case be that these violations are irreparable or reversible in nature. And as we look at the gravity of the violation here, we made the request as provided through the inspector, and I believe it was $1,000 fine, and based on the circumstances that will be consistent with what you've done for the time period of and the efforts that appear to have been brought forth by the respondent.
Anything further?
And I have nothing further.
Okay. Ms. Barnes, was there service of this notice of hearing on the respondent?
Yes. The package was delivered on January the 8th at 1:30 p.m.
Okay, so they were notified of this hearing. All right, so therefore, in case number 18, RTL 012418, I find the respondent, Erica Liska, to have been in noncompliance of Article 4, Section 4.1.a and Article 5, Section 5.2.a.2 of the Land Development Code, which prohibit short-term rentals in zoning districts not zoned for short-term rentals, and that such violations are irreparable and irreversible because the improper benefit obtained by the owner and the damage to the surrounding neighborhood occurs at the time the violation occurs and cannot be undone as provided for by Section 162.091D, Florida statutes, for the property at 314 Williams Avenue, and to have subsequently come into compliance on September 19, 2023, and hereby order that respondent shall pay a fine in the amount of $1,000 and not violate that section of the Land Development Code again, and that for any future repeat violation, the respondent may be placed on a subsequent agenda for a hearing before the special magistrate for consideration of a fine of up to $15,000 for each occurrence as per Chapter 162 Florida statutes. All right. Is there any miscellaneous business?
No, sir.
Okay. Therefore, it being 3:40, I call this proceeding to be adjourned.
Okay. I was just going to say this is